Very well. All the way from Karbala in Iraq.
Morning,
I hope all is well at home. All the way from Karbala. Honorable Kabe, how are you?
Morning,
I hope all is well at home. All the way from Karbala. Honorable Kabe, how are you?
Honorable Chabe submitted the apology. Chair is attending section 194 committee.
How are you?
At the same time,
Right.
the apology. Chair
At the same time.
attending section
Honorable
194 committee.
good morning.
At the same time,
Right.
the apology. Chair
At the same time.
attending section
Honorable
194 committee.
good morning.
At the same time.
Recording in progress.
At the same time. Honorable Nonsele, good morning. Good morning.
At the same time.
Recording in progress.
At the same time. Honorable Nonsele, Honorable Fiaz Jacobs, how are you?
Recording in progress.
Morning, Chair. Greetings. I'm just an observer
Fiaz
today.
Jacobs, how are
I'm
you?
just listening in. So,
Recording in progress.
greetings from far away. Travel safely, and I like your statement you brought out yesterday.
Yeah.
Greetings from far away. Travel safely.
No,
and,
thank you. Thank you.
I like your statement you brought
Honorable
out yesterday.
Jacobs, honorable members,
From far away.
good morning.
Travel safely.
No,
and,
thank you.
I like
Kuya
your
More,
statement you brought
honorable
out yesterday.
Jacobs, honorable members,
From far away.
Dumelang. No, thank you.
Abushen, Chairperson.
Welcome you all. Honorable members, Abshin. No, thank you.
Abushen, Chairperson.
Welcome. Let us welcome you to the Joint Portfolio Committee meeting on agriculture, land reform, rural development, as well as employment and labor. We meet this morning to celebrate the National Heritage Month. Hopefully, we are all going to showcase the diversity of our beautiful country and landscape of South Africa in the different cultural diversity that we embody. But ours today as this joint portfolio committee meeting, we are to receive a briefing from the specific department, from a number of departments who would be dealing with specific observations from the oversight that we have had in the 9 provinces, and what is emerging out of the insights, particularly about policy and legislation reviews on the living and working conditions of farm workers, on the living and working. We therefore, honorable members, Department of Agriculture and Reform and Rural Development, who will be presenting to the committees. We've also invited the Department of Employment and Labor, as well as the Department from Legal Aid in South Africa, and the Cooperative Governance and Traditional Affairs. Those are the presentations that we will be having today. But before we get underway, Mam Kakaza, any other apologies today? But before we get underway, Mam Kakaza,
Thank you, Chair. Chair, as I have already mentioned, Mamu Klape is attending the Section 194 committee, and then Mamu Brit is attending party-related matters. I only received those 2 apologies, Chair. Thank you.
Thank you, Mam Kakaza. From Employment and Labor, any apologies?
Morning, Honorable Chair. From the Portfolio Committee on Employment, I received As we know already, Honorable Junja, the chairperson, is on sick leave, but we have Honorable Nonsele as the acting. I only received an apology from Honorable Bagram.
Thank you.
Oh, sorry, Honorable Chair. We also received apologies from the Minister, the Deputy Minister, and the DG of Employment. But we have got Inspector General Gimu Liwa, who will be representing the department, Chair. Thank you, Chair.
Thank you, honorable members. As I am on virtual all the way from Karbala in Iraq, and being Friday, our day of prayer, at 12 o'clock, I will be departing for prayers, and therefore we will arrange for one of our honorable members to take over and conclude the meetings accordingly. But without taking much more time, let us invite the Department of Agriculture, Land Reform and Rural Development to take us through the presentation, which will be followed by the Department of Employment and Labor. And then we will pose questions to both departments. Then after that, we will take the other two presentations from Legal Aid South Africa, as well as from Cogta together. You may proceed. Department of Agriculture, Land Reform and Rural Development, DG. DG. Officials of the Department of Agriculture, Land Reform and Rural Development, you may proceed with the presentation.
Morning, Chair, and morning all the members of the portfolio committees and colleagues on the platform. I'm not seeing DG here. I have not received any indication that he will not be attending. It may be difficulties with connection. Probably he will join us. But without taking much time, we are ready to make the presentation. I will request Mr. Zulu to do the presentation. I just also need to indicate that we also have got our colleagues coming from the provinces attending this meeting as well. It's not only national office. Thank you, Chair.
Thank you. Makeba. Ndap. You may proceed.
Thank you very much, Honorable Chairperson, and good morning to honorable members and the colleagues. I'm going to take
from the end and running the presentation backwards.
I will correct it. I will correct it, and it's just that the way.
Okay. I saw your opening line was thank you, and there was a thank you slide.
Sorry about that, Chairperson. Thank you very much. I'm going to.
Please go ahead.
Yeah, Chairperson, I'm going to just at a high level take you through the issues that were raised by the committee. In terms of the briefing, we had about 7 matters that we needed to deal with, which I'm not going to dwell much on them on slide 1, slide 2. However, let me start with the issue on the first one, which deals with policies and programs, as requested by the committee. One, the committee members will remember that our mandate on land tenure reform comes from section 25(6), which is our where we are getting the marching orders. I'm not going to deal much about it, but whatever we're implementing, we're trying to address that constitutional promise. And secondly, we've got two legislations that are guiding us, governing the issues that provide for security of tenure for persons living in commercial farming areas or living on privately owned land, irrespective of a race, your Extension of Security Tenure Act, and the Labor Tenants Act, as we know it. Those are the two categories of persons that we find in these commercial farming areas in terms of policies and legislations that we have in an attempt to try and improve the living and working conditions of these persons. We also have a program that we have adopted as a department, which we call Reform Dweller Program, which has got 5 pillars. The objective of this program is to make sure that we provide long-term security of tenure to these persons and also provide them with sustainable livelihoods in terms of piloting the agri-villages, because our view now is that if we want to deal with the issues of security of tenure in these communities, the place of work must be different from the place of residence. So persons must have their place of residence, a place they call home, because they've grown out in commercial farming areas. We don't want to remove them from that type of environment. Hence, we are piloting agri-villages. The minister has directed us to pilot the SASH in the Western Cape, which are hotspot areas, KZN, Mpumalanga, and some parts of the province, of the 9 provinces. We've identified some areas in these particular provinces so that we can pilot these agri-villages to try and provide for long-term security of tenure and improve the living conditions of these persons. So there are other pillars which provides for legal and mediation services, as I think legal aid will talk to legal representation. And we have maintained the mediation services within the department internally to deal with these issues. Furthermore, on the policies regarding women, we don't have specific policies or programs that are targeting women, since tenure reform is rights-based. But what we do as a department, we have maintained information and kept register of women and youth that have benefited from the land tenure reform programs as we implement the 2 legislation, ESTA and labor tenants. So we have also, as the honorable members will know, established the Land Rights Management Facility precisely to provide legal and mediation services to these vulnerable persons, the farm dwellers, to protect their rights. Obviously, some of the reason being that landowners, they normally don't want to negotiate or negotiate with the department. They just send their lawyers and take matters to court. However, as the honorable members will remember, the legal representation has been taken over from the 1st of January, taken over by Legal Aid South Africa through the Department of Justice. We remain with mediation services, which we provide on a regular basis to mediate before we can even take the matters to court. The land redistribution program also, we also provide for women and youth. They are targeted in our land redistribution program through the beneficiary selection and land allocation policy to target women, irrespective of whether they are farm dwellers or not. But in terms of the policy, these groups, the women and youth, are targeted for land allocation or state land allocation within the department. The policies and programs, if I continue with them, we are part of what the SAPS has established. We have developed a strategy together with them to try and deal with the day-to-day issues that affects these communities in these farms. We have a program together with them, with the South African Police, although we are still finalizing the institutionalization of these structures so that we meaningfully participate as a department in this program, working with SAPS to deal with the day-to-day violation of land rights violations in these communities. We have also started the process of conducting or rolling out ESTA awareness campaigns. If this honorable committee and the honorable chairperson who would want us to update, we can do so on the areas which we have already rolled out the ESTA awareness campaigns, because we have noticed even during the oversight that sometimes the farm dwellers, the landowners themselves, they are not very much versed with their rights, the rights they have on these farms, how far they can go, and the landowners sometimes you find that they are not very much aware of what is the do's and don'ts in terms of the law in these areas. Some of these issues that affect farm workers emanate from the lack of understanding of the provisions of these pieces of legislation. They are the toll-free numbers, although some of them, they are not, if they contact them, the toll-free numbers, if they're not working, sometimes they're not working, but we are working closely with Legal Aid South Africa on their side and from our communication to make sure that the toll-free numbers are always available for people to access us. On the issue of 2.1, which the committee requested us to give them a breakdown of the panelists through LRMF, we have broken it down into two periods, 2016 to 2018. These are the numbers. Gauteng is leading in terms of the numbers of panelists that were in the facility, followed by KZN, precisely because of the number of cases that emanates from these particular areas. And more particularly Gauteng, most of these panelists and these law firms, they are located within Gauteng. You might find that it's not because of the number, but it's because of the concentration of these legal firms. For the period 2019-2021, we have these numbers. Gauteng still leading with 174, followed by KZN with 145 in terms of numbers of these panelists and followed by Western Cape, which is number 3. This is just the breakdown in terms of the gender. This area was still dominated, the legal fraternity is still dominated by males, as you can see, 2016, 2018, and 2019, 2021. On the number of cases received by provinces, these cases that are received by the provinces, they are referred to national office, where we keep a database and then we refer them for legal representation, for mediation services. During this period, 1,185, they were received with KZN having the majority of these cases, followed by Mpumalanga. As you will know, we remember when we were doing the oversight, there were quite a number of issues that were raised in these areas, and then followed by the Western Cape with 148 as being number 3 from the list. The next slide is just these cases. We have consolidated them per year as a register, and that information has been provided and submitted together with this presentation. I'm not going to go through each one of them. This gives details in terms of what is contained, how the cases were these 1,185, how they were resolved, and it's very much detailed, but we just attached the links of the database. On number 3, the number of reported cases, which are not necessarily forwarded for legal representation in provinces. We have done an analysis on each one of them. They range from evictions through court orders, illegal evictions without a court order, threats of evictions, constructive evictions, where persons are denied or farm dwellers are denied access to water, demolition of houses, there are disputes in terms of labor tenancy, but they don't end up in court. Barrier issues and livestock disputes, some the restoration of rights, persons they move out of the farms. When they come back, the landowner does not want them to come back. And also the access to water or basic services, the right of way, the landowner, they just close, put a fence, and the restriction of the numbers and demolition of residents. I've just repeated that. What we have done, Honorable Chair and Honorable Members, we have a register of all of these cases, which we have analyzed in terms of different categories, like I've presented. We will request that the committee allow us to send them the consolidated register. We have received from all the 4 provinces, Mpumalanga, Northwest, Northern Cape, Gauteng. We were still consolidating the information from the other provinces, KZN, Eastern Cape, Limpopo, Free State, and Western Cape. As soon as that is done, we will then submit the consolidated database or register. Because in terms of the law, each district, each province must keep this register of these evictions, of these land rights violations, including illegal evictions, that gets reported to the department. But however, Chairperson, there are some eviction cases or land rights violations that don't get reported to the department. And sometimes even the department, we see them on paper. That is why we emphasize on the ESTA awareness campaigns and also communicate with our communities in terms of where to report these cases immediately when they take place. On the issue of the monitoring, we were using the interventions, as I've mentioned, the mediation, legal representation, and also the referrals to court if mediation fails from our side of the department. And also we have got districts all over the country, in the 44 districts. However, the main challenge that we're having as tenure is the capacity that we have across the country. We only have 182 officials working on these matters. They're not only working on the evictions or ESTA implementation, they're also dealing with all the other 9 pieces of legislation, which therefore means we're very thin on the ground, which makes it very difficult to handle these matters. I think the Honorable Chairperson and the members will remember when we're in some of the provinces, you will only hear one name of an official being mentioned everywhere, precisely because that is the only official that is available to deal with all of these cases, including labor tenants. The terms of the amendment of policies to improve, ESTA has been amended. We have submitted the regulations which are going to be published for comments, so that we give effect to the amendments which are trying to deal with these issues and close the gaps in terms of the implementation of ESTA. It went past the cabinet, it was approved, and the president signed off on it. We have done the regulations which are ready to be published as soon as our minister has signed off on the regulations. The court also appointed the Office of the Special Master on Labor Tenants to work with us and fast track the resolution of the outstanding labor tenant claims, which are just over 9,000. The land rights facility, as I've said, we have now this financial year, from January, from this financial year, established a new panel since the contract expired for the land rights management facility. And the Legal Aid South Africa also has a new panel of attorneys, which are providing support to these communities. We also have a policy that was approved in 2018, which we are working with, which guides and provides for support to farm dwellers in an attempt to improve their living conditions. These are the amendments on ESTA. I'm not going to dwell much on them, Honorable Chairperson, if you allow me. But this slide just indicates the legal framework that is available to improve the living conditions. I'm not going to talk about the constitution, but we have got enough legal framework to deal with the issues that we have in terms of the current provisions of the acts, labor tenants and ESTA, and also other laws that are supplementary to our tenure reform legislation, like your housing, in terms of provision of housing to these farm dwellers, and also the right to basic services. And as you will know, Honorable Chairperson, there have been judgments to clarify this matter of who should provide for basic services and temporary shelter to these communities in case of evictions. These judgments are very clear. We also have policies within the department to provide for additional land to these communities if they want to embark on agricultural activities, and also land development support to these communities once we have acquired land on their behalf. This is the 6.1, where the committee requested us to give the figures in terms of the budget allocated to land rights to the LRMF, which then the LRMF, as you remember, Chairperson, the contract expired in December 2022. So we now don't have the LRMF as a facility managed by an external person or a lawyer or a firm of lawyers, but we are managing it internally. Legal representation is managed internally by Legal Aid South Africa to save the cost. On the land that has been acquired for labor tenants during the period, as indicated, as requested by the committee, from 2017 to 2018 to date, 32,000 hectares have been acquired in terms of the land tenure reform and allocated to farm dwellers in tightly. We can provide the actual properties in terms of the properties that we've acquired in extent of this 32,226 from this period, and the cost, as you can see on the far right. And we have also identified, categorized the number of women and youth that have benefited through this acquisition from these communities. This is from the inception, from when we started the program until to date. We just gave this just to show beyond the period that the committee requested us to do. The committee requested us also to give an indication on the share of the total allocation, budget allocation for land redistribution and tenure reform. However, program 3, the committee must note that it is a combination of 3 branches. However, in the first period of 2021, the branch before the merger between the 2 departments, we had, and the merger between the 2 former branches, land redistribution, land acquisition and redistribution, and land tenure reform. So because there were 2 branches, if we take on the left, for land tenure reform, in terms of the total budget allocation for program 3, it was 7%. When there was a merger into this new branch now, which is land redistribution and tenure reform, after the merger of the 2 departments, the allocation in program 3 is still lower. It was 11%, and then of the total budget allocation for the program. And then after adjustment, the share unfortunately decreased to 10%. If we compare the core branches in 2021 and 2021-22, the figures remains the same for the new branch, land redistribution and tenure reform under program 3 at 7%, and after adjustment, it decreased to 5%. In 2021-22, it was sitting at, before adjustment, it's sitting at 9%, and then later decreased to 8%. The 3 programs under program 3, the core, is this branch, land redistribution and tenure reform, is restitution and food security branch. That is the share of this particular branch against the total share of in terms of the A&E budget allocation. On this item, Honorable Chairperson, on the progress, on the issues that were raised during the oversight visits, we have our provincial offices here. Because of time, this will be a separate presentation. If time allows, if the chairperson allows the colleagues to just go through in summary on the issues. However, the report will be consolidated for this particular item 7. Thank you very much, Chairperson and honorable members.
Okay, but we can afford them 5 minutes or so to give a summary.
Honorable Chairperson, I will hand over to DDG Ndove, and I think DDG Provincial Operations is on the floor, if I'm not mistaken, Chair. Thank you very much.
Ndove, you may proceed. Just a brief summary on that.
Thank you so much, Mr. Zulu, and also thanks to the chair. I think the reports, there are reports that have been submitted to the committee already. It may be very difficult to have a summary because it was not prepared in such a way. It was reports that were individual provinces. I will suggest, Chair, if it is possible, that if that consolidation is needed, that it will be done and be forwarded, but the reports have been already forwarded to the committee, but at individual provinces. Maybe your guidance on that, Chair.
Repeat on that, Ndove. Just repeat that.
I'm saying there are already reports that were prepared by each province, which have already been sent to the committee. They are not in a summarized fashion, so it may take a bit of time if each and every province can make a presentation. So my suggestion was that because they have already been circulated, that if a summary of all the issues from all the provinces needs to be summarized in that fashion, that can be done, but we don't have a presentation that have got that summary at the moment.
No, Ndove, I thought you were going to just give a brief summary on the overall submissions of each province of what were the takings from there. But if you don't have such a briefing, then we will move on to employment and labor.
Thank you so much, Chair. We don't have that summary. We did not summarize that. Thank you so much. Yeah.
Thank you, Ndove. Honorable members, we'll take our second presentation from employment and labor. Then we'll field our questions of clarity on both presentations. Can we invite the DG of Employment and Labor to take us through their presentation?
Thank you, Honorable Chair and honorable members. I'm not the DG of Employment and Labor.
Please lower your screen.
I don't know how to do. Is it fine?
Please lower, yes, perfect. That's perfect. Thank you.
Okay,
yes,
thank you so much. Thank you. I was still saying that earlier on we received an apology from the DG of Employment and Labor. My name is Egimwilwa. I'm the Deputy DG responsible for Inspections and Enforcement Services, also the Inspector General of the department. Chair, if you allow me, I'm going to switch off my camera so that I take the members through the presentation. And Matapel will be beaming the presentation on my behalf. I'm not seeing it yet. So I just beg your indulgence, Chair, as we beam the presentation. But just as a matter of background, the approach that we've taken is to respond directly to the brief that we received from honorable members in terms of the living and working conditions in farming areas in the Republic. And Chair, just also to mention that on an annual basis, we do just under 280,000 inspections on average. And the agricultural sector or the farming community receives about 5 to 6% of that number that I've given. So if we go to the first slide, I think the first slide is just saying what is it that we're going to be providing in terms of the living and working conditions. Like I said earlier on, we responded directly to the questions that were raised. The first issue that I'm going to talk to, if we go to the next slide, is with regards to advocacy. We conduct advocacy sessions. And Chair, just to also mention that how we've designed our approach in terms of inspections, every inspector that goes out to workplaces to conduct an inspection, it is as a matter of principle and procedure, they're supposed to also conduct an advocacy session. It could be just a high level, but an advocacy session is part of the approach that we take when we go out to workplaces. However, we also do have structured advocacy sessions. So in that slide, we are showing that in the recent past, we had a seminar that was held on the 24th of June. And then we also had 3 seminars that were held in KZN. We're also giving the number of attendees there. We also had a national seminar that was held in the 19th of November, focusing on occupational health and safety. We had 3 advocacy sessions in the Northern Cape. These were focused to farm workers. We had radio sessions in the Northern Cape in the area of Uppington. If you go to the next session, I'm continuing with advocacy. We had stakeholder engagements that were held in Gqeberha and Komga, respectively, in those dates, the 20th to the 23rd of July. We had 6 formal advocacy sessions that were conducted in the Eastern Cape in the financial year 21-22. On the 17th of March, we had an advocacy session in Ventersdorp in the north part thereof. And then we continue. In terms of, I just need to point out that we've got a basket of legislation that we cover as a department when we go out to conduct inspections and farm in workplaces in the farming environment. What we've picked up as a matter of, because one of the questions that we posed were, are there any policy gaps and what could be done to close those? We found that when it comes to farm dwellings, which has been an outcry, and some of the things I've also experienced firsthand, where there are very serious atrocities around the accommodation that is provided to farm dwellers. Now, from a department's point of view, we look at the regulation of farm dwellings in terms of the sectoral determination 13 that talks to farm workers. So basically, it will give guidance in terms of what are the prerequisites that a farm dwelling should comply with, just from a point of view of the sectoral determination. For example, the sectoral determination will stipulate that where the farm dwellers live, there should be an ablution facility not more than 100 meters away. And then also the square meters of the dwelling itself is provided, and also that there must be, ventilation and so on. However, there are certain limitations when it comes to us trying to come in from a point of exclusively and also thoroughly dealing with some of the occupational health and safety related atrocities in the farm dwellers, because farm dwellers are ordinarily not designated as workplace. And in that regard, there's limitation of scope when it comes to coverage by the Occupational Health and Safety Act. And in some instances, you find that, Chair, I was once in a farm in Brits where in one room, I think there were about 6 to 7 adults, and the room was quite small. And however, when you look at that from the point of view of the BCA through the sectoral determination, you are unable to enforce when it comes to that. However, if our occupational health and safety was to be looked at and close also the gap in terms of enabling us to regulate the number of farm workers that could stay in a particular environment to avoid overcrowding. And I must say, Chair, that we're in the process of amending our OHS Act, and there's a bill that is active, and we're looking into using that opportunity to close some of these gaps so that we are able to then flag the arm of the law when it comes to regulating the farm dwelling environment. We go to the next slide. This slide is responding to the issue that was raised regarding the number of inspections that we conducted. For the financial year 21-22, we conducted 17,638 inspections in farms, and we've given a breakdown in terms of provinces. And you can see the non-compliant workplaces were about 3,000, and then we issued out 2,951 notices in that regard. Some of the notices could be one notice that would have several areas of contravention. Like, for instance, in the space of occupational health and safety, you could have one notice talking to several areas of contravention. Like, for instance, if there's a contravention with regards to say machineries that are in that area, and maybe licenses that are not provided for, and so on. If you go to the next slide, this slide is now talking to a breakdown in terms of the areas of the acts that we've covered. BCA and national minimum wage, we did, that took the bulk of our activities. So we did 10,393 inspections in total for the financial year 21-22. In terms of the Employment Equity Act, we did 338 inspections. In terms of the Unemployment Insurance Act, which also includes the Unemployment Contribution Act, we did 773. In terms of the Compensation of Occupational Injuries and Diseases Act, we did 538. In terms of the Occupational Health and Safety Act, we did 5,553. Now, this statistic is just answering directly issues that were raised around the BCA and contraventions that were picked up. So in terms of the working hours, we know that the BCA and the sectoral determination, if we go to the next slide, please. Yeah. The BCA and the sectoral determination stipulates clearly that no worker is allowed, unless if it's agreed, but no worker is allowed to work for more than 45 hours a week. And so that is regulated. So where we find that there is a violation of such, we found there were 2 cases. In terms of contracts of employment, the law also clearly states that every worker must have a contract of employment, because a contract of employment enables us to check details with regards to what is it that a worker has contracted to, from the hours of work to the nature of work to how much they're going to get paid, deductions, and so on. So we found that in 178 instances, there were no contracts of employment. With regards to annual leave, we found that there was one area where there was such a violation. A sick leave, there was one area, and maternity leave, there were 5 areas of such. If we move to the next slide, the next slide is talking about the contraventions that were found around, still we're looking at working conditions, the unemployment insurance fund. The law in terms of the UI states that there must be a declaration of workers on a monthly basis. For instance, if you have reported that you've got 10 workers working for you, every month you need to give an update to the UI on the numbers, so that we keep track whether the numbers are still the same or fluctuating. We found that 95 instances had violated that. They didn't declare on a monthly basis. With regards to contributions, it is the same. Monthly contributions have got to be made to the commissioner. We found that 89 cases had demonstrated a violation in that regard. We move to the next slide. There was a question around whether do we get involved in the contribution to pension or retirement fund, and also areas around medical aid or health insurance contribution. And the BCA and the as a primary law that regulates working conditions does not give us jurisdiction in that area, so therefore we don't cover that part. And then just in terms of how the mode of salary negotiations, there was a question around that. And what we've stated is that this is done through bargaining, the normal bargaining. And however, Chair, I need to state that in our observation, we've picked up that there's a dwindling level of unionization in the agricultural sector. And we know that it is a trend that is sort of pervasive in all the other sectors, but we see it quite sharply in the agricultural sector. And therefore, our approach as a department is that we have regulated the remuneration through the National Minimum Wage Act. The National Minimum Wage Act is clear. No worker should be paid less than a certain amount per hour or per month. So it's regulated in that regard, 23.19 Rand per hour. And so no worker in South Africa should be paid less than that. So how we get into this space is to make sure that whatever happens, and I also need to emphasize that all the sectoral determinations are still in force. So we use the sectoral determinations as well as the BCA and the national minimum wage. The national minimum wage is enforced through the BCA sections from 69 up to 72. If we go on. Now, what this slide is trying to answer is just to give members a sense of the notices that were issued in the 5-year period. So we're saying here, in that period, we conducted 28,158 inspections, and in the same period, we issued out 6,361 notices. The extent of corruption, there was a question that was asked. So Chair, you'll see that the stats here is quite negligible. And here we're talking to where there was a proven case that there was corruption, and So it was just in the Northwest, and 2 inspectors were involved. We've had numerous allegations and complaints that some inspectors are in the pockets of employers. However, we haven't had any substantive instances where it will be proven and there will be people that are willing to come forward and give you evidence and so on. So that state is just, like I said, an instance where it was proven. So we've got just 2 in that regard. And then with regards to seasonal workers, we know that in the area of farming, there is a use of seasonal workers. So it's a trend that you observe across the board. And what happens, Chair, with seasonal workers, something that we've picked up is that, especially in the province of Limpopo, we do pick it up in all the provinces, but in the province of Limpopo in particular, you find that seasonal workers are employed through employment agencies or labor brokers, and therefore they do not become part of the workforce of that employer. They would, so the labor broker takes the place of an employer, so to say, and if they are employed for a short period of time, when you find that maybe there's harvesting and so forth, and there's a need for additional capacity. So we have found that it is happening. I think the question went on to say, what will be the impact of this on the agricultural sector? And Chair, when I were unable to get into that detail, because to determine an impact, we believe that it should be preceded by conducting a sort of a study of some sort, even if it's a desktop analysis. So we know that we're not in a position to pronounce or speak to the impact as such. And if you go on, just in terms of the multi-stakeholder agreement with paralegal services, here in this regard, Chair, we are saying the department undertakes stakeholder engagements. We work with the CCMA, the National Prosecuting Authority, SARS, and trade unions and other worker forums on a regular basis. Our inspections take the form of coordinated inspections in one way or the other, and particularly when we conduct what we call or blitz inspections, that will be very highly coordinated. So in that regard, we're just trying to demonstrate the level to which we sort of coordinate or participate in the multi-stakeholder instances. We don't necessarily have some sort of an agreement with the paralegal services, but I need also to state, Chair, that one of our pillars besides advocacy and inspections is enforcement. And with regards to enforcement, where you find that you've issued out notices and the notices have not been complied with, and the compliance or the lifespan of the notice had expired, we then revoke what we call a referral for prosecution. And in that regard, we do have some working relationship with the NPA, although we find that it works better in some provinces than others. So I think, however, that what is helping us is that with the amendments of the BCEA, we are then able to send or refer a non-compliant employers directly to the CCMA. And in that regard, we're picking up that there's increased compliance, and we know that the award that comes from the CCMA has got the same weight as the award of the court. So we're picking up a lot of benefits with the shortening and also just using the CCMA as an arbiter, also just at the same level of the court, Chair. And then just in terms of the inspection strategy, and the budget. There's a slide that is going to talk to the budget. We don't have a budget specifically allocated to inspections. Our inspectors are specialists, so they cover all the workplaces. So for instance, an OHS inspector will have a role to play in the farm environment. An employment equity inspector will also have a role to play in the environment, and so on and so forth. So in terms of a strategy, we do have an inspection strategy which is overarching and not necessarily just focusing on the farming sector. And maybe that it's something that is worth thinking about, particularly given the fact that you do pick up that when it comes to vulnerable workers, I mean, they don't come worse than the farm workers. Farm workers are amongst the most vulnerable and the most exploited in the country. I'm going to go to the next slide. Like I indicated, Chair, this slide is just giving an overview of how much has been allocated per province. I do not want to take members through the details. I'll just go to the next slide that talks about our muscle in terms of human resources. We've got about 2,106 officials in the inspectorate. Of that, Chair, 1,950 are pure inspectors. We also have statutory services officials. We've got client services officers that are based in the office, and we've got provincial chief inspectors. We also have specialist inspectors that are housed in a head office that come in to assist on a specialized basis. And we really have improved, Chair, and I think it was last year, we finished the process of employing an additional 500 workers in the space of, inspectors rather, in the space of occupational health and safety. Currently, we are busy beefing up the area of employment standards. We are looking into bringing in additional inspectors to look into the area of employment equity. Currently, we're sitting with about 60 or even less employment equity inspectors for the entire country. We are heading in that area, and we're looking into bringing more inspectors. We're in the process of doing that. But I'm happy that when it comes to at least BCA, we've got more than 1,000 inspectors. Occupational Health and Safety Act, we've got about 670 inspectors. And the UI and COID inspectors, we put resources together with the funds, and the resources are not too bad. So we are able to move in that regard. And also just to emphasize that inspectors are recruited and appointments in line with the required qualifications for the legislation that they enforce. For instance, our occupational health and safety inspectors are engineers. And then we look at BCA, those are legal people. The minimum requirement is that they need to have a legal degree and so on. The last slide is just giving a breakdown of the human resources that we have, Chair. And we do not have stats in terms of labor brokering in the farming sector. I thank you, Chair.
Thank you, Mamo Egi. Honorable members, that is the briefing, both from the Department of Agriculture, Land Reform and Rural Development, as well as Department of Employment and Labor. We'll now open the session for questions of clarity or comments. Honorable Nontsele. Honorable Nonsele. Honorable Nonsele. Honorable Twete, you may proceed.
Thank you, Chairperson. I'm trying to open my video here. Thank you, Chairperson. But can I mute it, Chair? Because my network is not stable. I just had load shedding.
We'll never hear you if you are muted. You can close your video, but
sorry,
not be muted.
Can I close my video, Chair? I'm worried that I
Go
just
ahead.
had load shedding. So in case of connectivity, but okay, thank you, Mtem. Firstly, Chair, let me welcome the report, the presentation by the department, even though it was we received it very late, but we managed to browse through some of the issues, and also, Chair, allow me to register my disappointment on the fact that there's only one executive that is present, which is Mamu Chapa, Deputy Minister Chapa. And I want us to note that and as a concern. Moving forward, Chair, I have on the presentation of agriculture, I will only engage on agriculture for now, because this is a joint committee so that we give chance to other members. On slide 4, Chair, of the presentation, the department was asked to present the programs and interventions that targets women and youth. But Chair, on this presentation, there are no clear and straightforward policies targeting women. Can the department confirm if it is implementing programs that target women and youth on farms? If there are such programs, what are those? And where have they implemented them? That is the first question, Chair. My second question is on slide 5, Chair, of the presentation, where the department mentioned Indoyama agri-villages. As much as it is a pilot program there, Chair, there in Northwest, let me register my concerns and about this program, Chair. It might seem as a program that is intervening, but Chair, my concern is that this program of agri-villages might also, Chair, it might also, I'm fearing, Chair, that as much as we'll have these agri-villages, we might be, as the department, we might be creating some dumping sites, some dumping areas of farm dwellers. And which means, Chair, we are also in a way promoting or not addressing the issues of farmers that are evicting the farm dwellers. And my major concern, Chair, is the fact that is it the fact that maybe the department is acknowledging a failure to secure eternal rights of farm dwellers when we are saying let's pilot in Doyama agri villages. Lastly, Chair, on slide 18, of the presentation, proclamation of the date of coming into effect of the ESTA amendment. It is urgent, Chair. But on the slide, Chair, this is not specific. It says it will be on or before December 2026. Some officials during the oversight visit were saying the proclamation will be on September. Can the department confirm the correct dates of a proclamation of Esther? Is it September or is it December 2022? We know, Chair, the importance of this of Esther to us as Department of Agriculture and Farm Dwellers. Let me park there for now, Chairperson. Thank you, Tim. Modula Stool,
you are most welcome, Honorable Chwete. Honorable Inana. Bau Inana.
Hey. Thank you. Good morning to Chair and to the colleagues and to the officials. Chairperson, let me welcome the presentations that were made. And although I am on the Department of Employment and Labor, but because we had the joint session, let me just highlight some other issues in the Department of Agriculture that almost similar to the ones that my recent colleague has highlighted. About, excuse me, about slide 4, Chairperson, all of us, even South Africans, are aware that the farming community, the most people who are vulnerable are women and children. And we therefore need to have that program that we're talking about. What is it that is being done, or what is the policy that enhances the rights of the women, and so that they are recognized as integral part of the community, and the protection, therefore, of the children. In one of the area, Chairperson, that we visited, we noticed how the children who are of the school-going age were suffering in terms of accessing the education because of lack of transport. And there is not even the safety aspects of how to protect them as they are walking the very long distances. I was therefore expecting that slide 4 would have that program that clarifies what are the policies that empower women and protect their children, so that they are not deprived of their education and their well-being. And Chairperson, it relates as well to what is being said in the Department of Employment and Labor about the advocacy. One of the areas of advocacy, Chairperson, was to provide safety sessions and the awareness campaigns to the farming community. But on this advocacy, we are not very clear of what is it that being conveyed to empower to this community, because the community in the farms are very part of a very integral system to provide the entire world and with the food resources. And yes, if we don't have the policies in the program that empower and strengthen their existence, those will be failing. And about the agri-village, Chairperson, when we were attending the panel of that was appointed to look at which was called the high-level panel, one of the points that it raised was that before the tenants are removed, the Department of Labor must be informed, in particular the DG, of where are those people going to be relocated? Is there any alternative place for those people to be allocated? And if they are eventually evicted, is there anything that the Department of Labor is doing to give them the legal presentation in the courts? And I was therefore expecting, therefore, when you talk about the municipality, the following challenges could be encountered by the municipalities in the light of the above mentioned. The issue of incompetence by the municipality and the lack of availability of land and the lack of budget. Those are the things, Chairperson, that must not only be said to be at the challenges, but we provided with the solution. Now that we are confronted with the farms that are being evicted without following the proper procedure of notifying the DG, and with the municipality providing the available land, we are supposed to be provided with the alternative. What is it that the municipalities are doing in order to cater for the people in the farming area? And Chairperson, when you talk about the advocacy, we previously said, Chairperson, on our joint visit, that there must be a public engagement to educate the communities in the farming areas of what are their rights and what is it that is being done whenever they are confronted with the abuses. And if it is not appearing here, we will never know what is that we are doing, because when we go to the farmers, we are told everything about their dilemmas. But what are the solutions? The last point, Chairperson, that I wanted to raise, there was a common complaint in all the areas that visited, that the previous ministers, was one of them mentioned, Mrs. Squacha was one of the ministers was mentioned, that they came to provide with the solutions to their challenges that they were having. And they did not come back to provide what is it that is done. You may call, Chairperson, that you yourself, you said we don't want that to happen, that we come here just as to do the engagement without providing with the solutions. And some of us, we might come back, the same problem that people are raising, that they raised before, they are still going to raise it. We need, therefore, when we go out for this visit, Chairperson, when the problems are identified, we have the solution of how do we deal with this, so that we avoid the situation of if the next group that will do this joint visit will be provided with the same challenges. And it becomes a vicious cycle. And we need, therefore, to have a solution on how to break it. Thanks, Chairperson.
Thank you, Honorable Inana. Honorable Mkhonto. Mkhonto.
Ngiyabonga ndabezitha. Good morning to you, honorable members and colleagues from both departments. Chair, I'm having comments and questions. My first question to the Department of Agriculture would be, is there any possibility for these farm workers to access the legal representation from the the legal aid board or from wherever without involving the police and the officials. The reason I'm asking this chair is because they complained bitterly about the alleged corrupt activities and behavior by subs and officials from both departments, employment and labor and agriculture, rural development and land reform. So that is why I'm asking, Chair, is it possible for them to jump these people and access the legal representation? There is a slide from the Department of Agriculture, or whilst explained, it was that there are no women programs that they are having. But then during our oversight, Chair, we observed that children are also vulnerable. They are exposed to all sorts of wrong things. And in some instances, they are even deprived their right to education. So institutions like maybe Childline, the Human Rights Commission and so forth, have they ever been involved, or have they ever even thought of involving such bodies to make sure that these children are not exposed to the things that we observed there? Because, Chair, you will agree with me, it's abnormal for a very big family with teenagers to have only one bedroom with their children. There are a lot of things, and in most cases, everyone is drunk. You can imagine what these children are exposed to. Those are, that is one of my observation, Chair. And then, Chair, it's good that the Department of Employment and Labor is now agreeing that they don't have a specific inspection program for farmers, for the farming communities. They have all in one basket. But then I've been observing their vehicles in all the provinces that we visited. Even if the farming communities are in this one basket, but are there any vehicles, off-road vehicles, that are meant for those to access, for easy access to those farms? Because the ones that I saw in all the visits, there is none that you can say, at least this one can be able to access a farm with ease. So my question, Chair, there is to say, even if it is in this one basket, are there any vehicles meant to access farming communities? The issue of labor brokers, Chair, is not, this is a comment, is not only prevalent in Limpopo. Farm dwellers in the Free State, they complained bitterly about labor brokers. And they even told us that they are even defrauded because first of all, illegal immigrants are targeted by these labor brokers. They take money from people, promise them to be employed, and at the end of the day, they don't get employed. Thanks very much, Chair. Chair?
We seem to have lost Honorable Mkonto.
I'm done, Chair.
Oh, thank you. Honorable Mtabe. You may proceed.
Thank you very much, Honorable Chairperson, and good morning to you and the honorable members and the Deputy Minister that is present, the officials. I have a question for agriculture. On slide 17, Chair, what is being done to establish a structure that will be filled to make sure that there is capacity to deal with the evictions, especially on the eviction monitoring strategy? The second question on agriculture as well is on slide 18. The Office of the Special Master on Labor Tenants is appointed by the Land Claims Court. There are outstanding labor tenants claims totaling 9,333. What has been the success that has been achieved in relation to this working relationship? If there is, if we may be given, how far are we in reducing the number of these claims? On slide 22, legal services support to farm dwellers and labor tenants. The budget allocation and expenditure report refers to management fees of 159 million, as well as 161 million for the panelists.
Thank you, Honorable Mtabe.
No, I'm not done, Chair. I think the network does
okay.
Injustice to me.
Please proceed. Proceed.
Thank you. What is the value for money on these legal services and support and the expenditure that has been done in relation to what has been achieved so far? On inspection and enforcement, slide 6, do you have a database of registered farms in each province? If yes, what is the percentage of farms inspected per province? And what is the ratio of inspectors per province based on the database that you might have in relation to the number of registered farms in that each province? The last one on employment and labor is on slide 7, Chair. The number of inspected farms. What is the reason for lower inspections on the Employment Equity Act, UI Act, OHSA, as compared to BCEA and the National Minimum Wage Act? Does this have a relation or a correlation with the number of specialized inspectors that you have per province? Or is it because of the budgetary constraints that you could not therefore then be in a position to employ as required, as per your ratio per province in terms of the number of inspectors that you need to have? Thank you, Chair.
Thank you, Honorable Mtabe. Honorable Ntate Masipa.
Good morning, Chairperson. Thank you very much. And good morning to honorable members and officials. And thank you to the officials that done the presentation that went over. Chair, I don't have many questions, but I've got probably to pose to the department. During our recent visit on slide 6, they talk about the rapid response on rural safety. And Chair, during our recent visit in KZN, there were concerns obviously by farm dwellers regarding their safety and obviously the labor tenants as well. So the question really is this rapid response on rural safety, How is it operating, and is it integrating the labor tenants and farm dwellers and farm workers? Can the department really just give us a brief of meetings that they have had regarding this safety operation on the farms? Chair, I would have loved slides 13 and 15 link to be able to open. We're not able to open. If they can really provide with the presentations in a format that we can really be able to read. Lastly, Chair, the slide 25, budget for tenure reform is still aggregated. It is not easy to see what amount was budgeted to settle labor tenants applications, to provide legal services to farm dwellers, and to deal with ESTA acquisition or any ESTA intervention. Can the department present the report that really just itemize all the line items under the land tenure reform? Thanks, Chair. Lastly, I just want to really sponsor the concern raised by Honorable Chwete that we do not have the executive on this platform. I think, Chair, you need to also assist us. Let's get our ministers to come and really be with us here, because these are important issues. There are really concerns out there. We have seen how situations are with regards to this issue. So the ministers really are supposed to be here to respond to the issues that are raised by our farm dwellers and farmers in the country. Thanks, Chair.
Thank you, Honorable Ntate Masipa. We've taken note of that, but the Secretariat did register the apologies of Minister Mahmoud Diza, as well as the apology of the Minister Ubao Ulamola, and the Deputy Minister's apology, Ubao Jeffrey. So we will look into that and ensure that they participate in other meetings. Honorable Ntate Montwedi. Madume.
Chair, before I say what I want to raise, I think that Masipa also, it's a concern that we're raising. It's not that the fact that they've tendered their apologies, it is acceptable. It remains unacceptable that they've tendered an apology, not attending this very important meeting. My issue, Chair, is on the issue of illegal evictions that we see happening on various farms on a daily basis, where our peoples continue to be, subjected to very bad conditions in farms where they were born, in farms that they've called homes, where they've not had any area they called home, that only farms remains their homes. Now, I want to raise this concern to the department that I don't think the department is doing enough, Chair, with regard to reaching out to these people. On a daily basis in Ventersdorp area, people are being removed from farms, either constructively, so removed from farms, illegally evicted. There's one case where somebody was hospitalized, ambulance picking him up from the farm and went to hospital for about a month or so. Coming back from the hospital, the farm is closed and locked. That person can't access the land. Where there's another thing also where they mentioned that property belonging to labor tenants being regarded as part of private property, where a person has built their own houses there, but they are then locked out of their own house, they can't access because the farm worker, the farm owner decided to lock them out of their property. Now, I want to check lastly from the side of the department to say, what is it that needs to be done? What is it that we need to do as public reps, that we raise these things with the department so that they can attend to them as a matter of agency, because it's quite serious, this thing of our people being removed from farms by farm owners. I want to check from them, how quick do they respond legally? How quick do they go and take these matters to court so that they get to challenge some of these constructive eviction or these illegal evictions that our people on daily basis, Chair, are confronted with. I just want and I'm worried, Chair, that you'll find most of the time some of your departmental officials actually been the ones that advocate on behalf of these white farmers, where they are quick to tell our people to say, no, these people are willing to build for you a shack in the community there, go to the community and you must be build a shack there. Well, and they're saying, no, go, they will build you a shack there, you should be able to get a grant. Advocating in favor of white people. It's a serious concern that I've actually observed in quite a number of engagements, especially in the Northwest. But I'll retake those matters up with the department, hopefully that they
Thank you.
Okay.
Are you done, Honorable Montoedi? Honorable Montoedi? Okay, Honorable Ntate Hendricks.
Thank you very much, Honorable Chair, and Juma Mubarak to you. Honorable Chair, when I left the corporate world, I did volunteer work as a general secretary of a trade union, and we did a lot of work on farms. That's why I appreciate the presentations, and I'd like to thank the two departments for the updates. I would like to know, Honorable Chair, if there has been an audit of farms to identify wrongdoing in terms of apartheid policies, to open the doors to issue a right to occupy certificates to farm dwellers. Also, I would like to know, I see that a lot of research and visits has been done. Are there any indications of the return of the DOP system, which especially affected the colored farmers, and also slavery, even in modern forms? Can the Department of Labor, for example, give us a clear indication that they didn't pick up any signals of a DOP system or of slavery? Millions of rand are being paid to law firms, and we heard that accessibility is a problem because of the police and officials. We know that there are thousands of senior Black law students at our universities who can help with pro bono legal desks, which will provide easier access to farm workers than having to try and get to law firms. And they are and many of them, these law students come from the farms, and we should rather capacitate pro bono desks to speed up the work that is now being done by law firms at tremendous cost. Also, we would like to know whether the sectorial determinations as human rights muster so that it does not perpetuate a situation where people are paid below the belt. Lastly, Honorable Chair, I would like to get a take on whether our inspectors, and I believe there are many inspectors of the Department of Labor, are they satisfied that there's equal pay for work of equal value for females and also teenagers compared to males? Thank you very much, Honorable Chair.
Juma Mubarak to you too, Honorable Hendricks. Honorable Kapa. Wow, Kapa.
Thank you, Chair. And thanks for the presentations. I'll be brief because I'm looking at mainly one issue here. There was, at the beginning, there was some comment which was implying that there's lack of understanding of legislation, both from the farm workers and the farmers. To me, that would be interesting. First of all, I would like to say I'm looking at that from two angles. Real lack of awareness versus arrogance. That is even found the part of the farmers. To me, this is a problem because if the farmers have a situation where they employ private security to protect their property, they also have farm watch to protect their property. It removes from me the issue of not being aware of their rights, because they seem to be much aware of their rights more than the farm workers. At the same time, you can see that all these things are happening despite existing legislations. And therefore, to me, it will be interesting to see whether there are loopholes in the current legislation that will make us as lawmakers to make sure that these laws are made effective or amended to have a meaning to the situation of the farm workers and the farm dwellers. You will pardon me, Chair, if I'm in this program of looking at the situation of the farm workers, farm dwellers, and farmers. You will excuse my emphasis on farm workers and farm dwellers, because that is a main issue of the essence of this problem on the farms. So I would look also, while I want to understand this lack of understanding versus arrogance, and whether there are loopholes, on the efforts to make sure that there is this awareness of legislation, is there any problem or any progress? Because if these efforts are made and therefore there's no chance, there's no possibility of change, we should know that, so that maybe there should be another way of doing it. Because as I insist that all these things are happening while we do have legislation. And therefore, if the legislation provides only for part of the farm situation or farming community to be looked after, and the other part of the farming community is not well looked after, and if this is in our legislation, we have a responsibility to understand this and make sure that this is what is being done, because there is no way we can do all these oversight visits and come up with no change. Because you remember that our people were saying sometimes that you have always coming here, you will come again and we'll get nothing. And I don't think we expect that this is going to happen this time, because it was on the instance of the parliament that this work was being done. And therefore, I think we are expecting to come up with a good product, which will be in the interest of those people that we saw on ourselves, how they are living, how they are treated. That is, I emphasize, besides the existing laws in our country. I thank you, Chair.
Thank you, Honorable Kappa. Honorable Hendricks, can you lower your hand? Honorable members, is there any other honorable member who may wish to pose a question who I have not recognized? Honorable Hendricks, may you please lower your hand. Any other honorable member who wishes to pose a question? Dr. Matias?
Oh, my Lord.
How
are you, my Lord?
No, tsesabo my Lord DALRRD mo South Africa, Khoshi or Nkosi is appropriate.
Akere wena, my Lord, ka Sotho ke re morena,
Yeah, morena wa loka. No, wa loka morena. Or Khosi vile ka Sotho ya loka ka bani morena might speak to a king. And I'm not Zelban's Talinjebo, he's my senior, he's a king.
Ka Sotho a rena kgosi ke Setswana le Sepedi.
Yeah, no, proceed, my lead.
Ka Sotho re na le morena le morenana. The morenana will mean chief.
Yeah, then I
no,
submit
okay.
according.
Okay, no, thanks, Honorable Chair, for the opportunity. And greetings to colleagues. And may I also join a long list of my colleagues, members of parliament, who welcome the presentations. Look, Honorable Chair, with the work that we have done as the joint committees, it would have been fair that the executive is present and is part of these discussions. So I will also register my disappointment with executive or ministers, deputy ministers are not part of this hearing, meeting. Be as it may, Honorable Chair, the sky will not fall even if they're not here. We'll proceed with our work and as we are proceeding. Honorable Chair, look, research, evidence-based information about the plight of farm workers, farm dwellers, and labor tenants is out there in abundance, in vast quantities, for one to lay their hands on such evidence-based information. Honorable Chair.
Proceeding to Matthias, we're listening.
So it shouldn't be difficult for officials to get information. That's the first point. Secondly, in the research data information that is available out there, it is on record that of the 3 programs of land reform, those being land redistribution, restitution, as well as land tenure. Land tenure is one of the most which has not been given adequate attention to secure land rights of labor tenants. And the Department of Agriculture, Land Reform and Rural Development should be presenting this information to us. And should present it in graphs and in figures that shows, indeed, this is a program which is lagging behind. And in lagging behind, it is also indicated by the appointment of the special advisor on labor tenants, who is saddled with about not less than 9,000 outstanding labor tenant claims. Yet it's also disappointing and shocking to see that so much of millions, if not billions of rands, have been spent in the name of labor tenants. The question is, for which I hope the department official will answer, who benefited out of such billions of rands if we are still faced with the challenge of this most important program lacking behind? Now, Honorable Chair, not so long ago, we were in public hearings across the country. We were in the last province where we went to is KZN. And soon after our visit there, I'll give just a specific case. A matter was brought to attention in Bergville in Ukasham of an absent farmer who inherited a farm from her late mother. An absent farmer came to serve notice on, I will not mention the name of the farmer, but I will mention the name of the victim, of Mr. Msebenzi Hlombe in Winterton. And in serving such notice, not notice of eviction, but notice of constructive eviction. And this happens soon after our visit in KZN, in which a whole lot of limitation and restrictions were imposed. I'll share this letter with you separately, National Chairperson, for which I've shared with the minister and I ask her intervention. Mr. Gombe has 65 cattle, 20 sheep, 25 goats, and 8 horses. And in the letter of restriction or limitation of rights, he's been instructed to have all his livestock. Further than that, he's been imposed with measures such as measures of movement, of grazing, of access to graves on the number of people who can visit him. And that rights of burial or burial rights have been withdrawn. These are the living realities that our people face on a daily basis. These are lived experiences, realities that people live with on a daily basis. Now, I think we have been played here with by officials, Honorable Chair. I'll go to the very last slide of the Department of Labor and Employment. The slides that says, there is no data on the number of labor brokers in the farming sector. This is the department that makes this point. And yet they are telling us they've got so many inspectors who have conducted so many inspections in so many farms across the country. Now the question is, as they were going about such inspections, and they discovered that in Limpopo in particular, farmers are engaging services of labor brokers. Why can't they give us at least the number of labor brokers in Limpopo? Than to say that there's no data at all of labor brokers that are being engaged by farmers on the countryside. I think we have been taken for a ride, we have been lied to. Officials are smart at concealing information. And this concealment is as a result of 2 factors. One, they're not doing their work. 2, they are trapped in the culture of the impunity of no consequences for not performing their work. This confirms what people have been telling us, that officials bayabambatiswa. It confirms that. So the question that I want to put to the Department of Employment and Labor, why do you lie to us? Why don't you give us the statistics of Limpopo? Because it's clear that Limpopo has been your obsession. I don't take this. And for that, Honorable Chair, the reports that have been presented now of both Department of Agriculture, Land Reform and Rural Development,
Can
as
you
well as
conclude, Dr. Matthias, conclude?
it is not truthful. Honorable Chair, as I referred to availability of data, and this is evidence-based, these two departments should have gone to two reports. A high-level panel report on their findings, and also they should have read the report commissioned by International Labour Organization and authored by Fessers and Ferrer in 2015 on farm workers' living and working conditions in South Africa, key trends, emerging issues, and underlying and structural problems. At least they should have plagiarized that report and present it here than what they have purported to be presentations, and that they are non-presentations. So I don't take as real presentations because they negate the work that we have done for more than 4 months, if not more than 6 months, through public hearings.
Thank you,
Thanks,
Honorable Matthias. But you should not misrepresent the Ndebeles. Ababamthisi bayafumbathiswa. That's what the Ndebeles were saying. Bayafumbathiswa.
Bayafumbathiswa, Chairperson.
Yes. Honorable members, if there's no other honorable member I've left out, I will pose a few questions and then hand over to the departments for their responses. I think I should touch on what was alluded to earlier by the Department of Agriculture, Land Reform and Rural Development. Mambabata, Mambabama. I'm speaking. Now I requested that honorable members must put up their hands, and they did. I identified all of them. And then I came back again and requested if there were honorable members that I had left out. Honorable Matthias was the only one to come in, and therefore I took the platform to speak.
Apologies, Chair. I think it
So
was
if we
because I was
abandon
booted
our
out.
gadgets and we don't follow proceedings, we don't hear these things.
No, Mhlekazi, my gadget was booted out when Matthias spoke, Honorable Matthias
Yes.
spoke. So I did not hear that
All right.
part. But let me leave it. Carry on, Chair. It's fine.
No, please proceed.
Oh, no, I thought maybe you were rushing for time. Thank you, Chair. I'm a little bit despondent in terms of my responses because I'm really struggling to reconcile what we saw on the ground and what is being said here by the department. And having said that, I am also taking cognizance of the fact that the department has said that they are thinly stretched on the ground. So I don't think we should be too hard on them as well, even though, you know, when you look at what is happening on the ground and you hear what they are reporting, it seems to be chalk and cheese, really. We do not see the effect of all the programs that they're talking about on the ground. And I don't think it's only the provinces that my group went to, but having listened to my colleagues, I see that we seem to we seem to be bringing up the same issues. So I'm really worried, you know, about what will happen going forward. Is the status quo going to remain the same, where the department says they are thinly stretched on the ground and therefore cannot reach everybody?
what we have seen on the ground, is that also going to carry on? I'm even making an example here of the agri-village that we saw in the Northern Cape, Chair. The houses were great, the yards were fine, but it was just like a village that is dumped in the middle of nowhere, where there were no schools, there were no clinics, and all the other needs that go with a community like that. So what is the plan around these agri-villages and talking to other departments who are responsible for education, for health, etc., etc.? Are we talking to those departments to make sure that when we do put up these agri-villages, we also have services that will be required or are required in any village, in South Africa? Chair, I hear that we are talking about a register of evictions and eviction monitoring strategies, and yet, evictions and especially illegal evictions are very rife. That's what we've heard on the ground. And I don't know if the department is really being realistic here. Will they really be able to have a register of these evictions at all and follow up on each and every one of them, especially having said that they are thinly spread on the ground? Again, they talk about ESTA awareness and dedicated teams conducting land rights awareness campaigns and including rights to permanent secure tenure. What we heard from people on the ground who are living on farms is that they hardly ever get to see the department officials, because the department officials end up at the gates, and some of them are sent back from at the gates. They don't actually enter the farm to talk to the people. Some of them, as Ntate Matthias has said, bayafumbatiswa, banikwa igusha, banikwa intoni. So it's really difficult, Chair. It's very difficult. I'm finding myself a bit lost, because what do we do? There is a problem with capacity with the department. The programs are there, but the programs do not reach the people at all. So what are we going to do going forward? And I think that is the challenge that we are going to have as a committee. When we are alone and by ourselves, we have to really think of what are we going to do to make the situation better, because it's pointless just listening to the department or just going out on oversight and then leaving it at that. Something has to be done going forward. Nkosi Madiba. Mthembu omkhulu ndicebile.
Muted, Mpankomo. I was speaking and realized that I was muted. Let me thank the input from the honorable members. We'll take responses from the department. But firstly, I must state, honorable members, that we have not seen any of the reports that the department alludes to have been submitted. If any, we have only seen 2 reports from the Northwest and Limpopo province. Can therefore, unless there are others that were sent this morning, which we have not seen nor received, otherwise for us it would be misleading to suggest that all the reports from the provinces have been submitted. I'd like Ubaundobe to clarify this, and can the department inform us the status quo with these reports? Secondly, honorable members, the Department of Agriculture, Land Reform and Rural Development has stated that its farm dweller program is linked to the district development model. And during our oversight visit, I do not remember any site visit where the department was able to demonstrate how the DDM works in farming communities, especially with regards to tenure security. Can the department, honorable members, give us one example of such a case and submit a written report about the DDM interventions to support tenure reform? Honorable members, of the key policy to accelerate and by farm workers. In this presentation, there is nothing mentioned about this policy. Can the Department of Agriculture, Land Reform and Rural Development confirm if this policy is still being implemented, and further submit a written report about the 50-50 cases across the country? On our experience as the joint portfolio committees on agriculture, land reform and rural development, as well as employment and labor, during the recent oversight visit in KwaZulu-Natal, we made one question on security concerns of farm dwellers and labor tenants are catered for. For example, if I may speak to the Mchali family around Normandy, which have reported to the portfolio committees that they lived under constant harassment of SAPs. The landowner and private security firm, being Itemba Security, working together with the local police at Normandy. People reported constantly that they were being beaten, their property was damaged, livestock was being stolen and impounded unlawfully by farm owners, to the extent that there was a figure of about 865 head of cattle that had been impounded and never returned. Police cases have been opened, but yet there are no investigations, no prosecution, and nothing is being done at all to assist the farm dwellers. People have reported that they have lost everything. The question of safety, of rural safety strategy is very important if it can be perceived to be one-sided. And I think in this regard, we would like to understand what is the department doing to ensure that the safety of farm dwellers and farm workers and labor tenants is protected. Another question I may pose, honorable members, to the department is, can the department submit a report about processing and the settlement of all labor tenant claims across the country, including a budget plan, expenditure as well as budget requirements for settling outstanding labor tenants applications? Honorable members, on slide number 23, it does not inform the committees which acquisitions were made in terms of Section 4 Ester Farms or Section 26 of LTA. It makes it difficult, therefore, to assess the impact of these sections. Can the department further clarify this? I will now hand over to the departments for responses. Department of Agriculture, Land Reform and Rural Development, Makeba Obaundobe, you may proceed.
Thanks so much, Chair. And also greetings to Deputy Minister I did not realize she was in the meeting the first time I was talking, and any other ministers that could have joined the meeting. I just need to clarify the issue of the reports. Chair has requested. I suspect there's been a bit of communication challenge in between as to which reports needs to be submitted. I just verified now through the processes that we, channels that we are using for getting information. It was that as much as all reports have been done, but the ones that were specifically requested were the 3 reports from Northwest, Limpopo, and Northern Cape. However, the other reports are also available. So I think what we could do is to ensure that all the reports are submitted, but the 3 are the ones that we were told are requested. That could be a bit of miscommunication in between, but that can be corrected, Chair. Moving beyond that, I'll again request Mr. Zulu and his team to respond to issues that has been raised by members. Thank you so much.
Thank you very much, Honorable Chairperson and the honorable members for the questions. And also thanks to the Deputy Minister. On the first one, Honorable Nonchele, Honorable Chwete, on slide 4, yes, indeed, as we have mentioned in the slide, regarding the programs for women and youth, yes, in the department, through land redistribution, we do have those programs. And we were specific about tenure reform, as I've mentioned in our policy on beneficiary selection and land allocation. The women and youth are a priority, are a target. We are targeting women and youth and farm dwellers in particular. Those are living in commercial farming areas. They are a target. That policy is very specific in terms of allocation, that 50% of our allocation must target women. But that is the other program, not land tenure, which is our land redistribution program. It does prioritize women. Maybe we would have to be specific in terms of that particular program under our Chief Directorate Land Redistribution. On the issue on the piloting, slide 5, on the piloting of agri-villages, yes, Honorable Chairperson and the honorable members, it is a concern which we have tried to explain, but the manner in which we intend to implement or pilot agri-villages, we've got a situation where as a department, we acquire land for farm dwellers, but for the mere fact that they have been subjected to these limitations and land rights violations, limitations in terms of renovation of their houses, access to basic services, etc. We are saying, let's apply the model as we acquire and give them long-term security of tenure on their own land that we've acquired at the state. Let's apply the agri-village model to bring about all the services to these communities. That is how the model it is. However, there are instances where there are lawful evictions. Remember, honorable members, in terms of the current law, evictions are lawful provided there is a court order. In some instances, the department, through the legal representation, the matter is fought in court. However, a judgment comes out and say the persons will be evicted. What we are saying is, when we recycle those persons, let us make sure that we cycle them in an agri-village setup so that they have got access to services. I understand the model in terms of what happened in the Northwest is not what the program is. The program is set up in such a way that all the other parties, all other government departments, including the municipalities, they must be involved and participate. depending on their mandate in terms of the constitution, where they have got to provide water, there must be infrastructure, there must be all the amenities that are required by those particular communities. That's how the model it is. So we are very also careful about taking these agri-villages. It was debated at length as dumping sites. That is what we are trying to avoid, so that the farmers use these as dumping sites to evict people and then dump them in some agri-village. It's not what the program objective is. It's a situation where we have a court order, people have been evicted, or the land is not enough wherever they are, because the Act ESTA does allow for on-farm and off-farm settlement. If the circumstances guarantee that wherever they are, because in some instances, these farm dwellers, they were put in very rocky, in the mountains, some of their houses where development cannot happen. They are located in very, very bad areas within these farms, because the farmers, they wanted to put them on the marginal areas in these particular farms where it would be very difficult for the municipality and government to provide services. So in those instances, even if it's within the same landowner's land, but it's a movement from portion A to, or relocation from portion A to another portion within the same, depending on the settlement agreement. However, that is what we are saying, the agri-village must apply. We try by all means, not even try, we prohibit any situation where these become dumping site or the cleaning of these farms through the program of government. On slide 18, the issue on the regulations. The process currently, once we have, through our legal services, the regulations have been drafted, vetted, they go through our political principals for sign off, then we publicize for 60 days. I think the estimate of December, it was because of the process that we have to go through to say by December, we should have published this for public comments for 60 days. Hence, there was an issue of September to publicize them for 60 days, so that by December, we have the regulations and the inputs from the public on those comments from the public on those regulations. Currently, they are in the process within the department for signature. So within the timelines that we have put forward, we are hopeful that by December, those regulations, the 60 days will have been completed. On the second one, on the Honorable Hinana, on slide 4, I think it's the same as the issue around the program for youth, which I've alluded to. However, as this particular department, since we are responsible more on tenure issues, the security of tenure of persons in terms of our mandate. However, we come across these situations where the youth, they don't have, or children don't have access to other amenities in terms of their rights. We normally refer such matters to departments like your social development, like your Department of Education in that particular area. Like, for instance, we were in KZN, I think the honorable members we were with, they will remember there was an issue of school transport. We have requested our colleagues in the province to engage with the Department of Education and the Department of Health to come in and intervene, because that falls outside our mandate. But however, we don't have specific programs to deal with such issues which affect those communities, but we refer such matters to the relevant departments. The agri-village raised also by Honorable Hinana, I have already alluded to that on the issue of the agri-villages, and then the public awareness campaigns on the issues of evictions. I think Honorable Hinana raised an issue on the evictions. In terms of the current law, the evictions are lawful provided they are in terms of the court order issued by the court. If the eviction, there's no court order, is an unlawful eviction. We always, but as a department, currently now, since January the 1st, we do that through the Legal Aid South Africa. Legal Aid is the one who provides legal representation. We always defend both, even if it is going to court or is legal. We always appeal those judgments, and we win some and we lose some. But on the illegal evictions or unlawful evictions, that's a straight cut. We defend all of those through Legal Aid South Africa. I think Legal Aid also, when they come in, they will talk to the processes that they've put in place, working with the department and the communities in accessing those kind of services. On the ESTA awareness, yes, we have rolled out some in other provinces, but we're still rolling it out. However, because of capacity constraints, we agreed to say maybe we'll need to deal with the issue of capacity and get capacity that will help us to roll it out, specifically more particularly after the oversight visits, which we realized there seems to be issues and communities, even the farm dwellers, sometimes they don't even know where do they get help, because in the ESTA awareness campaign, it's not about the legislation, knowing their rights, it's also where they can get support, assistance immediately when they are faced with such evictions. Honorable Mkhonto, on the issue of the legal representation for farm workers without going through SAPS or officials, yes, that is part of the program through the Legal Aid South Africa. The communities can go directly without going through the department or going through SAPS to get that legal representation. On the issues on the women programs as well, under Honorable Mkhonto, I've addressed that in terms of the rights of children, etc., etc. As we get involved in these communities, our approach is that we refer such matters to the relevant departments, social development, education, and others, to provide for those issues that affect children and in these communities. We also have on Honorable Ndabe, slide 7. Yes, we have a situation of the capacity, as I've mentioned in the slides, in slide 7. However, as a department or as a unit, especially tenure, we have realized in the branch that is undercapacitated. The structure does not talk to the mandate of this particular unit. We have already developed a proposed structure, which is going to be discussed during the session. We have a session next week from the 5th until from Monday to Friday, which is rolled out in the department to look at the fit for purpose structure, depending on aligned to the mandate of this new Department of Agriculture, Land Reform and Rural Development, because they were just merged, the two departments, and we have not gone through a process of now looking at the fit for purpose structure aligned to the mandate of the new mandate of the department and including the old mandate. So we have the proposed structure to try and deal with the issue of capacity. Depending on that process, we are hoping that when the process is completed, as we reach the next financial year, at least you would have an approved fit for purpose structure to deal with these issues. We have tried to cover all the areas under tenure which are undercapacitated to deal with this particular issue. On the budget allocation for LRMF, by Honorable Ndabe, we spoke about the value for money. We will provide the cases and which cases were successfully concluded. Yes, indeed, as a department, we had reviewed this process because exactly of what Honorable Ndabe has raised in terms of the amount of money that was paid to the LRF managers, and we realized that no, that is why the two ministers made a decision to remove, to transfer the legal representation to Legal Aid South Africa, and then the department will remain with the services of the mediation, which is now managed internally, and we are busy procuring sub capacity to manage these services within the department. And also LASA, Legal Aid South Africa, has taken over legal representation, and they are busy capacitating themselves. I think Legal Aid will talk to that. On the issue of the labor tenant claims outstanding, what are the successes? We will provide the plan that the special master presented to the department in terms of how they intend to fast track, work with the department to fast track and expedite the resolution of the outstanding over 9,000 labor tenant claims. So that can be provided in writing if the chairperson allows us to do so, which I think it will be part of the reports that the chairperson that he asked the department to provide. And the issue on the Honorable Masipa, slide 6 on the rapid response. Yes, Honorable Chair, on that strategy, working with the SAPS on the rapid response, we attend those sessions. However, part of the things that we are doing now as a department for meaningful participation of the farm dwellers, because they're supposed to be part of those structures, we are going to be rolling out the establishment of the land rights management committees, which are committees prescribed by the ESTA Amendment Act, that there shall be such committees that represent the interest of all the farm dwellers in each district. There will be that type of a committee that will be representing the interest of the farm dwellers, and they will then form part of the structures in the rapid response institutional structures or governance structures in each district and at a provincial level. The issue on the slide 25, the budget that is allocated for tenure is allocated under what we call the household grants item code in terms of finances. But finance can discuss it, can expand on it. But however, that budget is not separated between labor tenants and ESTA. Is one amount, and because precisely that's how the financial allocation is done to this program for tenure, is combined. There's no separation in terms of percentages. I think the reason is precisely because where you go to a farm, you will never find labor tenants only. You find labor tenants together with farm dwellers. And therefore, as we circle a labor tenant claim for 2 persons in one farm, you find that there are 20 other farm dweller families in one particular farm. So the strategy was, or the approach is that when we acquire that property, circling the labor tenant claims for 2 families who lodge the labor tenant claims, we must as well provide security, long-term security of tenure of all of the families within a particular farm that we're acquiring. So that is why when we negotiate for the acquisition of the entire farm, so that the families that are there, they all obtain a long-term security of tenure, which then becomes difficult to separate the budget for farm dwellers, settlement of a labor tenant claim, and farm dwellers in terms of ESTA, because in each farm, all the farms, is a combination of the two. They are all farm dwellers. It's just that the other families did not lodge the labor tenant claims by 31st December 2001, but these conditions and circumstances under which they live are similar. The other ones, they just lodged an application during the campaign for labor tenancy. But when we we provide security of tenure to all of them at the same time settling a labor tenant claim. Hence the budget, it will be difficult to separate because for these two types of programs. Honorable Matswedi, the illegal evictions, the right of way, I've covered that, which is part of what we're doing to prevent through Legal Aid South Africa. They will talk more on that. I've presented that in terms of the process that we follow through Legal Aid to take those matters immediately to court. And that is direct contact between the farm dwellers. But what we have realized is that some of the farm dwellers, they don't go directly to Legal Aid South Africa, yet they are allowed to go straight to Legal Aid South Africa without going via SAPS or the department officials. But what we, during the ESTA awareness campaigns, one of the things that we're doing is to assist them, educate them on how can they go straight directly and report immediately to Legal Aid South Africa for legal representation without any further delays. The issue on the Northwest matter, we'll follow up on that one, on the issue around officials advocating for relocation of farm dwellers, which is not what we're supposed to do as a department, because the right of persons are on the farm. However, if there is an agreement between the parties because of circumstances, it's the resettlement, it's off-farm settlement, is not us advocating for relocation of farm dwellers willy-nilly without following the law. Honorable Hendricks.
Can we conclude?
Okay. Other matters, Honorable Chair, the DOP system in the Western Cape. We know in the Western Cape, the labor tenancy was not applicable. We'll further research that, but we are dealing with the matters of farm dwellers in the Western Cape, which has become one of the hotspots in our work. Honorable Matiase, we also noted the issues he has raised, and we also note the issue of Mr. Msebenzi Zombe. Will follow up on that matter with Legal Aid South Africa. Honorable Papama, yes, it's true. There are issues around our capacity, which we are addressing, as I've mentioned. The Honorable Chairperson himself, we have noted the reports that you will want us to provide, and we will definitely do so after this meeting. Thank you very much, Chair.
Thank you, Bauzo. But I must also put it to you that it is not correct that we requested as the joint committees 3 reports. The letter that was sent out to the department stated clearly that we want all the reports. So please ensure that those reports are sent to the respective joint committees by no later than end of business day today. Honorable members, we will now hand over to the Department of Employment and Labor. But I just also wanted to add to the questions posed to them in terms of building a capable and developmental state is one of the priorities of government, and the public sector is critical to this. Can the Department of Employment and Labor, with all the said inspectors, which they have alluded to, that they have, all their inspectors are law graduates. How many of these inspectors are working without law or legal qualifications? If they can clarify that for us. I will at this juncture hand over to Honorable Nontsele to chair the rest of the proceedings and the 2 presentations of Legal Aid South Africa and Cogta. Honorable Nontsele, you can take over.
Thank you, Honorable Chair.
You may proceed.
Yes, thank you, Honorable Chair. Good day, honorable members and presenters as well. Can we then proceed to invite the next presentation? You can proceed. Can you share screen for us as well?
Sorry, Chair.
Okay.
Am I not going to respond to questions posed to the Department of Employment and Labor?
Or you want to come? You can then take the minute before the presentation then.
Thank you, Chair. There were a few questions that were posed to the department.
Sorry to legal aid, but don't take all your presentation off screen. Okay, you can proceed.
Thank you, Honorable Chair. In terms of what was raised by Honorable Mkonto with regards to cars that are fit for purpose, I think point taken. Most of our current fleet struggle when it comes to accessing some parts of farms that could be problematic and challenging. However, there's an option of hiring short-term vehicles, and that is open in terms of being used. Then, in terms of what Honorable Ndabe raised on slide number 6 regarding whether we've got a provincial databases that stipulate the registered farms and the ratio of inspectors in relation to that. Chair, may I request that you be provided with an opportunity to present that information in writing at a later stage. I don't have the details at this point in time. In terms of slide 7, still raised by Honorable Ndabe, the reasons for lower inspections in the area of employment equity, UIA, COID, it's precisely, number one, due to the fact that it's linked to the number of inspectors in those disciplines. And also, Chair, that when you look at the prevalent of challenges, that they relate mostly to conditions of employment, basically their bread and butter issues. And therefore, that is why you'll find that with regards to BCEA and national minimum wage, our resources are skewed towards that. However, like I indicated earlier on when I was presenting, there is a need to beef up capacity in some of the areas. With regards to the issues that were raised by Honorable Hendricks on whether are we aware of slavery tendencies or apartheid anomalies. Chair, we test the prevalence of exploitation through our laws. For instance, paying below the national minimum wage is seen by some as modern day slavery. So how we pick these things up is through the national minimum wage enforcement. Working conditions that could involve elements of exploitation as well as working environment that could do the same are also tested via our the basket of legislation that we have. With regards to whether our sectoral determinations have a human rights element, Chair, I just want to indicate that in actual fact, all our laws safeguard the rights of workers, and we regard worker rights as being human rights. On the question of whether we look at equal pay for work of equal value, as well as ensuring that there are no pay disparities between men and women, we to some extent, and to a large extent actually, we test that through our Employment Equity Act. And in this instance, we conduct what we call Director General reviews, which will be a substantive way of looking at compliance with regard to the Employment Equity Act, rather than just a procedural compliance. And lastly, with regard, the one but last, the point that was raised by Honorable Matthias on the issue of labor brokers and the fact that we indicated that we don't have statistics for labor brokering. Whilst I understand where he's coming from, I also need to put a point that from a legal point of view, with regards to our laws, we don't necessarily deal with labor brokers. Labor brokers assume the position of an employer, and in terms of our instruments, legal instruments and processes, they are regarded as such and recorded as such. And in terms of the last question that was raised by the Honorable Chair, in terms of how many of our...
Is that a point of order?
Yes, Chair. Sorry, Chairperson. It's Honorable Chwede
Recording in progress.
Okay.
In fact, I wanted to check, Chair.
She's about to conclude.
No, Chair, I just wanted to check, Chair. Sorry, legal aid.
Okay.
I wanted to check, Chair, since when she was giving a response to one of the critical answers, the recording just stopped.
Yes, I noted that as well.
Can she go back to that first one before she concludes, Chair, so that it can be recorded? Because that is a critical a part of what was asked also. Thanks, Chair. So,
Thanks, Honorable Chwede. Can you help us for just to recap on that area?
Okay.
That was not recorded.
Thank you, Honorable Nontsela. I think it was at a point where I was talking about the point that was raised by Honorable Matthias regarding the point that you made on the very last slide, that you do not have statistics in the area of labor brokering. And I was saying that although I understand where his argument is coming from, I also need to make a point that when it comes from our legal framework and legal point of view, we do not deal with labor brokering. We deal with either employers or employees, and labor brokers take the position of an employer in terms of our processes and prescripts, and we record them as such. And the last point that was raised by the Honorable Chair on how many of our inspectors are working without a legal qualification. If my understanding is correct, I just want to put it on the table as well that none of our inspectors are working without a legal qualification. All of them are qualified as they should in their areas of disciplines. Thank you, Chair.
Oh, sorry, I was muted. Thank you for the responses. I think that part has been covered now. That is where on the outstanding responses from the Department of Employment and Labor. Can we then, honorable members, if there are no further points, proceed and allow legal aid to do its presentation? Can we proceed with legal aid then?
Thank you, Chairperson. Honorable Chairperson and honorable members, my name is Mantiti Kula. I am the CEO of Legal Aid SA, and I will first accord our board chairperson, Judge Motsamai Magume, an opportunity to start with the meeting. Thank you.
Thank you, and good morning, honorable members of Parliament. Thank you very much for giving us an opportunity to give our 6 months report, because you realize from what has been said that we only took over this unit in January this year. What preceded this takeover was the Portfolio Committee on Justice had been over the years asking us to take over this issue of legal representation because of the problems that they noticed that legal aid was best suited in respect of access to justice to attend to this issue. Our takeover was not without problems, and all the problems were as a result of, us having to take over a unit that has been there and which involves other ministries. When we took over the issue as a board, there was no money transferred to us. As a result, we as a board took a conscious decision to vote in on an amount of 33 million from our reserves to start the unit in January this year. We were then able to employ people to start setting up structures within the unit. Money only came in April. 33 million rands only came in from Treasury in April this year. We had already started. So it was as a result of the board that we were able to take over. You will notice from a presentation that we have done as much as we can from the issues that we took over from agriculture and management. So mine is just to also tell you that I'm not alone. I'm also accompanied by the Deputy Board Chairperson, Datem Vundlela. We also have, I'm also accompanied by a board member, Matumele Seilan, who's Chairperson of the REMCO. And there is also Professor Dumeda, who is also a board member and Chairperson of the Audit Committee. On the staff level, not only is Mantiti there, the CEO, but we also have the COO, Mr. Sitopa, who is also with us, and the CFO, Tinzolo Mufokeng. They will be in the position to answer certain of the questions that may come up. We have noticed also that from the questions that have been asked, that a number of some of the questions really relate to what legal services are we able to, or have we offered. We will then be able to demonstrate how far we've gone, and that we'll be able to do the job. Thank you very much, and over to you, Mantiti.
Thank you very much, Chairperson, Honorable Chairperson, honorable members, and also the Honorable Deputy Minister present. Good afternoon, and also the members of the board, as announced by our board chairperson, and also the management exco colleagues. The chairperson omitted our chief legal executive, Dr. Patrick Handemark, and also our legal executive for land rights management, Mr. Tabiso Mbenze, who will be co-presenting with me. In terms of the presentation outline, we have included the background that relates to the transfer of the land rights management unit from Department of Agriculture, the transitional arrangements that we had, the funding of the new land mandate as already touched on by the chairperson, and also our service delivery model once we have taken over the function from agriculture. And also we have then, in terms of the mandate for this session, touched on the land tenure rights violation, the tracking and monitoring of those evictions, and analysis of the handover files that we received, and the recommendation for policy mechanisms to promote access to legal representation. And before we begin with our presentation, I just want to thank both the Department of DOJ and CD, who is our shareholder and the executive, and also the ministers and the Department of Agriculture for the cooperation that we received or enjoyed as we were facilitating the transfer. Had it not been the cooperation of both these, our shareholder and the Department of Agriculture, Land Reform and Rural Development, the transfer would not have happened. We started co-managing with them from July last year to December 2021. And the transfer, we are happy to say the transfer was duly concluded in line with the transfer of function as outlined in the PFMA framework. And in line with that framework, a memorandum of understanding was drawn up to regulate all pertinent matters relating to this transfer, including the financial arrangements. And that after the transfer on 1 January 2022, both the Department of Justice and also the Department of Agriculture assisted us in negotiating with National Treasury requisite funding to enable us to carry this mandate. And in terms of the transitional arrangements, legal aid took over 740 matters with a contingent liability of 144 million from the Department of Agriculture. This includes 645 active members and 95 matters in abeyance. And our legal executive land rights management will go into details with the categories of these matters when he deals with the violations. And to ensure a seamless handover, we are utilizing the panel that was used by the RMF for the transitional period. And this was done in a bit so that we can allow that matters proceed without interruption. But there was a prerequisite that all those panel of attorneys that were rendering the service before had to accredit to the legal aid as a judicare system, and also that there was a requirement that they be compliant with the National Treasury Central Supplier Database requirements before they are accredited on our legal aid SA system. To date, we have accredited 184 legal practitioners across the 9 provinces, and they are highlighted. And as you will see, most of our practitioners are in the KZN, Western Cape, and also in Mpumalanga. And also to facilitate a smooth transition, we also the board adopted the LRMF tariffs for the interim until we work through all the legacy or the handover matters. The chairperson has already touched on the funding of this new mandate. When we took over the function on the 1st of January and March 2022, for the first quarter or the last quarter of the previous financial year, legal aid was able to implement the new department's internal management infrastructure and service delivery infrastructure due to 2 funding streams. As the chairperson has already alluded, the board availed 35 million that surplus funding that was ring-fenced for the provision of legal representation in land rights in accordance with the National Treasury regulation. And this was purely done because the transfer date of 1st January was fixed, but the transfer had to be done in line with the transfer of functions as outlined in the PFMA. And the transfer had to be signed by the 3 ministers, our Minister of Justice, Minister of Agriculture, and the Minister of Public Service and Administration. And to mitigate the risk, the board availed this seed capital while we are awaiting the transfer of the 33 million from the Department of Agriculture. That money was subsequently transferred on the 1st of April. And when we finalized our financials for the previous year, 2021-2022, because we have already taken over the function, we had to account for the 740 transferred files and the verified contingent liability for that handover file was this 144 million. And this 144 million was excluded in the provisions for the MTEF that were contained in the MOU. But with the cooperation of Department of Justice and also with Agriculture, when we had the bilaterals with National Treasury, we were allowed to provide for 25% of that contingent liability for this financial year 2022-2023, which amounts to about 29 million. So in terms of our available funding now that we're running on, it's the 24 million that we rolled over from the last quarter of 2021 and 2022, and the 33 million that we received from the Department of Agriculture from the 1st of April. The MTEF transfers were not done on the 1st of April. They will only be done during the midterm budget review. So the 118 million that's earmarked for the 2022-2023 financial year, we will only receive it at the end of December or at the beginning of January. That then constrains us in rolling out the full service delivery model that we have put forward for managing this new function. In terms of the service delivery model that we are utilizing, as I've already alluded, for a smooth handover, we are currently still utilizing the panel, provided they are credit on our Judicare system and also that they are CSD compliant. We intend, once we get the full funding, as outlined in the previous slide for the MTEF, that we intend to follow a salaried legal practitioner model per province to provide this legal presentation in a bid to promote accessibility. We'll have also adopted the decentralized model per province and region to localize and improve accessibility of these legal aid services. The internal legal practitioners will be trained and capacitated to handle all land-related matters. And our current legal quality assurance program has also been adopted by this new unit. In the first year, that is from January and for this financial year, we are managing the unit from national office until we receive the requisite funding to cover the rollout of the proposed national footprint. And that's the constraint that I alluded that we would not fully roll out our service delivery model until we receive the allocations that has been provided for in the MOU and in the MTEF. And in terms of our national office structure, it comprises of the legal executive, that Tabiso Mbenze, who will take over from me shortly. And because we have a confidence of the support of the department and also of National Treasury, we have commenced with the rollout of the provincial footprint from August this year in anticipation of the midterm budget transfer of that 118 million in January 2023. Each province will be divided into regions, and the number of regions established and legal practitioners will be allocated to each region. And the determination was made by considering the number of cases that were transferred to legal aid, as well as an anticipated increase in the number of land claims to be referred to the Land Claims Court by the Land Claims Commission and the Department of Agriculture. And in the next slides, which I will not go into detail, it depicts the proposed Land Rights Management Unit, national and provincial organizational structure. And the slide on the screen depicts that the staffing per region, per each province, also highlight the number of regions within a province and what we will initially provide for all our local offices to be able to render the legal representation. Each office will have a supervisory legal practitioner, a senior legal practitioner, a junior practitioner, and a paralegal. I will then hand over to our legal executive, land rights management, Mr. Thabiso Mbenze, to take us through the land tenure rights violations. Thank you, Chairperson.
Thanks, Ms. Mantiti. Mantiti. Thanks.
Yeah.
Thanks. My apologies. Mr. Mbenze, your platform is yours.
Thank you, Chair. Honorable Chair, honorable members of portfolio committees, deputy ministers that are present, board members of Legal Aid South Africa and colleagues, good day. We have listed 7 categories of land tenure rights violations. The first one, we have listed evictions. We are talking about matters where the landowners have issued court papers for evictions. These matters are in court. Secondly, we are talking about threats of evictions, where we are talking about matters where the landowners have threatened to evict occupiers. You find that in some of them, the landowners have given the occupiers letters, and in some of them, they've threatened them verbally. There are no letters that have been sent to occupiers. Third, we are also talking about the denial of burial rights, where occupiers are denied the right to bury their deceased family members on farms. And this one is very sensitive because on the one hand, the landowners, they feel that they've got rights to property in terms of the Constitution. And on the other side, the occupiers, they feel that they've got right also to bury their deceased family members on farms. So there are conflicting rights. We have also listed the constructive eviction, whereby the landowners are making living conditions of the occupiers unbearable. So they do this purposely in order for the landowners, they want the occupiers to voluntarily vacate their farms. We have also listed the interference with occupiers' grazing rights, whereby the landowners are reducing the grazing rights of occupiers. We have listed the renovation of houses as well. This one also, this one is very hot as well, because on the one hand, we are well aware that the occupiers, they occupy houses that are dilapidated. So whenever they want to renovate those houses, the landowners are saying that, no, you can't renovate those houses. And some of the occupiers, they want to use bricks whenever they want to renovate their houses. And the landowners are saying that, no, you can't do that. This is my farm, so you can't do that. We are also talking about cutting off access to water by the landowners, whereby the occupiers had access to water and the landowners had cut off that water. Okay, can we proceed? Okay, in this slide, we have listed the matters that were received from the department. We have received 740 files. These files, they include matters that are active and matters that are in abeyance. We have received about 645 matters that are active and 95 matters that are in abeyance. In this table, we have listed the categories as well as the provinces where these matters emanate from and the total figures. The evictions, you can see that in the Western Cape, we've got about 88 eviction matters. So that is where there's a lot of matters, eviction matters, and most of these matters are in the magistrate's court, because in the Western Cape, the landowners, they bring these applications in the magistrate's court. As well as threatened evictions, we have also mentioned threatened evictions, and the total is 9 there. Burial matters as well. We have 4 burial matters. access and maintenance of graves as well. That is also an issue. Mpumalanga is leading when it comes, Limpopo is leading when it comes to those issues, the access and maintenance of graves. We have restoration of rights as well. We've got 27 in total. Protection order, we've got 1 protection order. Relocation, we've got 2. Renovation of houses, we've got 4. Impounding of cattle, we've got 1. Restitution of land rights, we've got 223 matters. In total, we've got 740 matters. In this slide, we are talking about the land rights violation from February to August 2022. This is a mixture of matters that we inherited as well as the new matters. We've got 4 burial matters. We were successful in 2. We were unsuccessful in 2, but 1 of them is currently on appeal. Evictions, we've got 235 numbers. We've got 1 successful. We have 1 unsuccessful. Restoration of rights as well. We have 3 successful, 0 unsuccessful. Declaration of labor tenants as well. We have 1 successful and 1 unsuccessful. Okay, in this slide, we are talking about the tracking and monitoring of evictions, how we track and monitor evictions. The evictions are tracked and monitored through our national footprints of 128 offices. We've got 128 offices in South Africa. We've got 64 local offices, as well as 64 satellite offices. We've got the toll-free advice line as well. We've got the Please Call Me facility as well. And also through the collaboration and regular engagements with all stakeholders in the land justice sector. They also assist when it comes to tracking and monitoring evictions. These stakeholders includes the Department of Agriculture, non-governmental organizations such as Women on Farms, AFRA, and UZI. We are also working with universities and other state departments such as Cogta, municipalities, and premier offices. In addition as well, Legal Aid conducts an outreach programs whereby we visit communities for the purposes of training, advising, and tracking and taking statements from them. So we visit communities for the purpose of taking statements, advising them, training them in these kind of cases and issues. And also there have been a focus on women empowerment in land-related matters. We are also focusing on that. Engagements targeting female legal practitioners forums commenced in June 2022, whereby we are training advocates and attorneys in land-related matters. We have had 2 sessions with attorneys and advocates, one in Sentin and the other one in Northwest. In this slide, we are just analyzing land matters. After receiving the land matters, we have gone through the pleadings that were drafted in those land matters, and we have established that in almost all of them. So Section 26 of the Constitution was not pleaded. I'm just talking about eviction matters, whereby we know very well that that is important when it comes to the issue of emergency housing. The Housing Act is important. Section 26 of the Constitution is important. National Housing Code as well is also important. We also analyzed the Section 15 of ESTA. We have seen that Section 15 of ESTA does not include the safeguard to prevent or limit the risk of homelessness of occupiers. In terms of Section 15, the court can issue an order for immediate eviction of an occupier. So we are just saying that that is unconstitutional because it does not say that the court must satisfy itself that suitable alternative accommodation is available. With regard to Section 15, we have already started. We have instructed one attorney to challenge the constitutionality of Section 15, because while we are assisting individuals, we are also looking into cases that will have an impact on a number of people. So the farm occupiers are not aware of their security of tenure rights as well. We are aware that a number of farm occupiers, they are not aware of their tenure rights as well. So some of them do not even know where to report the violations of their land rights by landowners. As well as we are also communicating with the Land Claims Court, and the Land Claims Court is complaining about poor quality of legal services that is provided to farm occupiers, labor tenants, and land claimants by some of the panelists. So we are also training the legal practitioners that are providing legal services. We have had 3 sessions with them. One was in Gauteng, the other one was in the Western Cape, and the other one was in KZN. So we are also proceeding to train them. And also, we are also saying that the attorneys will be encouraged to appear and represent clients at the Land Claims Court. However, in complex matters, the briefing of an advocate should be permitted, because we are avoiding a situation whereby the attorneys will be post boxes. So they need also to appear in the Land Claims Court. They must move these applications as well as conducting trials. In this slide, we have listed on the left-hand side, we have listed the strength. We have also on the right-hand side, we have listed the weaknesses. On the strength side, we are just saying that we've got legislations in place in South Africa, so that is the strength. We are also saying that the state is able to provide legal services through Legal Aid South Africa. That is also the strength. We are also saying that the legal practitioners, we've got the legal practitioners who are willing to assist with legal representation in land-related matters. We are also saying that Legal Aid South Africa national footprints of 64 local offices as well as 64 satellite offices. We've got that as well. We've got toll-free advice line. We've got please call me facility. But on the side of weaknesses, we have identified the poor implementation of legislation. We have identified the limited number of dedicated judicial officers to deal with land matters. We know that the Land Claims Court, we don't have sufficient judges at the Land Claims Court. We have listed the legal practitioners have limited exposure to land matters. Some of the legal practitioners, they've got limited exposure when it comes to these issues. We have also identified that the land occupiers and labor tenants are not familiar with their rights, and also the limited use of ADR as well. We are also saying that no adequate guidelines as to what constitutes just and equitable compensation. We know that the landowners, they are just inflating the price, and we are coming to recommendations for policy mechanism to promote access to legal representation. On the left-hand side, we have listed the legislations that will be affected if our recommendations are implemented. On the right-hand side, we are dealing with recommendations. The first recommendation is that practice directives and rules of the court, the Land Claims Court, must be amended to the effect that each judicial officer hearing eviction cases under ESTA and the LTA are obliged to ensure that the occupiers facing evictions are legally represented in courts. We are saying that there should be a practice directives, and also that should be in the rules, so that each and everyone that is facing eviction must be represented, legally represented. We are also saying that ESTA and LTA should be amended to the effect that the judicial officers hearing an eviction case must arrange legal representation for the occupier facing eviction. I have already said that. We are also saying that all magistrates' court eviction orders must be subject to automatic review. That should be stated, because we know that some of the magistrates in some of the areas, even though that is in the legislation, but they don't refer their decisions to the Land Claims Court in terms of ESTA. so they don't know that they're supposed to do that. Some of them are doing that purposely. We're also saying that the court should be encouraged to direct that in eviction cases, the mediation is important. We have all listed 3 legislations, which is LTA, restitution, as well as ESTA. We are saying that these legislations, they encourage the use of non-litigious methods, such as mediation and negotiations to resolve disputes. We are also saying that they also permit the use of arbitration instead of approaching court in certain circumstances. We are also saying that the Land Claims Court is empowered by Restitution Act to recommend alternative dispute resolution. Okay, we can proceed. Okay, another recommendation, we are saying the Magistrates Court must be empowered to stay the proceedings at any stage if it becomes evident that there's an issue which might resolve through mediation. And also to say that to the parties, they must attempt to resolve that matter through mediation and negotiation. We are also saying that Section 16 of Land Reform Labor Tenants Act must be amended. The amendment to Section 16 of LTA, which relates to the cutoff date for applications for acquisition of land, is needed. Because you'll remember that the cutoff date is 31 March 2001. And a number of labor tenants were excluded because they did not make an application before that cutoff date. We are also talking about the reference to Section 3(1) of Land Reform Labor Tenants Act to labor tenants being able to acquire land that they were using on the 2nd of June 1995. We're saying that that should be removed because that also, because in terms of the Act, the labor tenants are entitled to acquire the land that they were using on the 2nd of June 1995 for grazing, cropping, as well as residential. We're saying that that is unfair. So they should be able to acquire land that they were using even before that. We are also saying that Section 11 of Land Reform Labor Tenants Act must be amended. The LTA states that an eviction notice must be sent to Director General, and Director General must convene a meeting between labor tenants and the owner in order to attempt to mediate a settlement agreement. However, we are saying that there's no record showing that the Director General complies with Section 11. So we are saying that there should be an amendment. The amendment is needed to make provisions for mediation compulsory before the matter is heard in court. We are also saying that Section 19(2) of Land Reform Labor Tenants Act must be amended. It should be removed altogether because it says an associate's right to reside should not depend on a labor tenant's right. So Section 9(2) states that on the death of a labor tenant who has retained the right to occupy the farm in terms of the provisions of Section 1, subsection 1, all his or her associates may be given 12 calendar months notice to leave the farm. We are just saying that that is unfair. That should be removed. We are also saying that Section 24(4)(d), Section 24(4)(1), Section 24(2) of Land Reform Labor Tenants Act should be amended because in terms of that section, there's a word applicant. It says the word applicant should be substituted with the words the Department of Agriculture and Land Reform. A labor tenant cannot be expected to pay the compensation to the owner of the affected land or to person other than the owner whose rights. Because in terms of that section, it says that the applicant must pay for that, not the department. So that should be amended as well. Can we proceed? Okay, we are also talking about Section 13(1)(a)(b). We're saying that it should be removed as well from the Land Reform Labor Tenants Act. In terms of this section, it states that with the exception of issues concerning the definition of an occupier, okay, if an issue arises in the Magistrates Court or High Court that requires the court to interpret or apply this act, which is Land Reform Labor Tenants Act, no oral evidence has been led. Any oral evidence has been led, and the court shall decide the matter in accordance with. We are saying that that should be removed altogether. This section. We're also talking about Section 9(3) of ESTA. So we're saying it should be amended and that the courts are not permitted to hear matters in absence of probation reports. because there's a tendency now for court hearing matters, whereas there's no Section 9.3 report, which is the probation report. So some of the courts, they hear matters without that report and say that we'll just write the judgment when we receive the report. We're saying that that is not okay, because the court will not be able to scrutinize each and every aspect of the eviction. Okay, we are saying that Section 8.5 must be amended. We are saying women and children who are survivors of an occupier who falls under Section 8.4 of ESTER are not protected, because they are also given that 12 calendar months that I noticed that I have mentioned above. We are also talking about Section 15 of ESTER. We are saying that it should be amended because it allows the court to grant an immediate eviction without looking into the issue of alternative accommodation. Okay, we can proceed. Okay, we are concluding. Please proceed.
CEO, you are muted. We can't hear you.
Thank you, Mr. Handemark. Thank you, Chairperson, and thank you, Mr. Mbenze. In terms of our conclusion, for the newly created unit, the LRMU, within legal aid, our priorities for the next 6 months is to improve the internal delivery model with due regard to the demand for the legal representation in land-related matters, and also to support our shareholder, the Department of Justice, in finalizing the medium-term expenditure framework funding with National Treasury to ensure that we have a fully funded mandate to continue to collaborate with the Department of Agriculture, Land Reform and Rural Development and the Chief Land Claims Commissioner to optimize the LRMU operations and ongoing training programs for our internal legal practitioners and also for our judicare practitioners, and when fund permitting, to roll out our provincial footprint so that we improve accessibility, and also to monitor the services that are provided by this judicare legal service delivery offering through our quality assurance program, and to collaborate with all stakeholders in the land justice cluster. So those would be our priorities for the next 6 months to mature this newly founded department within Legal Aid SA. Thank you, Chairperson, and thank you, honorable members. I will then hand over to the Chairperson if he would like to say a word before we close. Thank you.
Yes, thank you, Matiti, and honorable members. Thank you very much. I hope that we've shared a bit about ourselves, and in conclusion, we'll also depend on you whenever our minister approaches finance department to please be lenient on us when it comes to funding, that we've been operating on restricted budget, but we've tried our best under difficult circumstances. So we hope that whenever our minister makes a presentation that to increase our budget, please support him. Not that we're not aware that of the difficulties the country is going through, but you are aware of the load of work that is with us at the moment. This is a huge department. This is a very huge work, political, and it's very sensitive. So we would like to do a proper work. Thank you very much.
Thank you, Chair. Thanks for the concluding remarks and also your introductory remarks. Also, thanks again, Legal Aid Board through Ms. Manditi and Mr. Mbenza for the presentations that you have made. Can we suggest to honorable members that we take the last presentation so that when we open for questions, we do for both Cogta and the legal aid. Unless legal aid, I'm sure you at least you can wait for that presentation, and then we take them both for questions. Can we do that?
Agreed, Chair.
Yes,
Thanks.
can do that. Fine.
Thanks. Can we then allow Cogta to make its presentation whilst we're waiting for them to share their screen? We again note the apology. I've just been advised of the apology of SALGA because they've got a mayor's conference and they could not be available for this week. Cogta, the platform is yours.
Yes, good morning, good afternoon, Chairperson, Honorable Chairperson, and members of the Joint Portfolio Committee. My name is Mpho Morale. That's me, and then I'm also here with the SALGA conference. I am leading the team to respond to the request you made to our minister to share with you the perspective. And I'll ask my colleagues to flight our presentation in the meantime so that I can talk to it. I do have a few colleagues that are going to, one of them will also share with, will come in later to share the perspective, the legal perspective which we have requested. While they are busy flighting the presentation, allow me then to also indicate that you ask us to cover 4 areas in terms of our presentation. The first one was to talk around the challenges of eviction and the role of the municipalities that can play to support farm dwellers and victims of evictions, especially provision of temporary shelters provided, and also maybe where possible must provide an example. We are also supposed to share the implications of the High Court judgment at Pietermaritzburg on municipalities. It's a matter between Mushengu and others, and also Musunduzi municipality and others. And then we also were you ask us to cover also the issue of provision of basic services, and the issue of, lastly, to sort of propose legislative amendments, if any. But obviously, just to give you the overall perspective of our minister with the committee pertaining to this matter at hand. I'm not sure why is the president not being flighted?
It's not yet flighted.
Mr. Shike, can we flight it, please?
Good afternoon, Honorable Chair and members. Can we request the Secretary to give us the right to share, please? Thank you.
Mr. Sakaza, can you please help on that together with the DALRRD team? Can you please help us?
Yes, Chair, I've just made Mr. Shike now because I made Mr. Mukhalim for the cause because I thought it was him. So it's fine now.
Thanks, Mr. Sakar.
No, thank you very much. We can go to the slide number 5, I think. Yes, so this I've already covered. Let's go to number 4. Yes. No, Chairperson, apologies for the slight hiccup. On the matter of challenges, with regard to challenges of evictions and role that the municipalities can play to support farm dwellers and victims of eviction, and especially around provision of temporary shelter. Yeah, we are from our side as Cogta, we are indicating that where eviction has been granted by the court and the rights and needs of the elderly, children, disabled persons, and household headed by women has been taken into account, the municipality has an obligation to undertake the following as put under those 4 bullets. The first one is to carefully consider in implementing the eviction process, obviously respecting the human rights, and follow up in detail the directives ordered by the court over the eviction proceedings, and providing the occupiers with an alternative accommodation with water and sanitation facilities, and where there are immigrants, determine the status of such and assist those who qualify to apply for housing. Well, there is an area where the challenges could be experienced by municipalities. Let's go back to the slide. Sorry, Tadeshik. Yeah, there are areas that can be encountered by municipalities during the implementation. You know, in some cases, you find that the municipalities they just fail to implement court directives, and in some cases, there's maybe the municipalities do not have land to relocate the evicted dwellers, farm dwellers, and then in some other cases, there is a issue. Most of our municipalities do not have their own budget. They depend on grants, which are in most cases are committed. Then they don't have budget to provide for that. But some of the municipalities do try through their mayors to set up, mechanisms or funding for this type of these emergencies and unforeseen circumstances. But in short, you're going to find that most of the municipalities that have budget constraints, and then it's not able to really respond to that particular matter or event that will have arise. Let's go to the next one. So the second one area of is the role that you ask us to articulate is the role the municipalities can play to support farm dwellers and victims of eviction around the provision of temporary shelter. We are articulating to say that municipalities play a key role on water provision through water truck supply or tankering, and also VIP toilets, where this need arises. And then in some of the leadership also engage local businesses to assist and NGOs to come and provide provide food and temporary shelters, and municipalities with regard to the farming community. I think we're urging municipalities to really foster more strengthened relationship with the farming community, so that there is that closer collaboration. And then you ask us an example that we will quote. There is this one that happened recently in the Littleton area in Centurion, and then the court ordered the city of Tshwane to provide shelter to the affected people, and which was around 109, but only 66 were catered for. And then later the court was able to order the city to really make sure that all the affected people are catered for in terms of the relief. In the next slide, Chairperson, we will be sharing with you. You ask us to reflect on this court judgment, and I'm going to ask my director, Ms. Swanabile, to take you through this particular case and also share with you what are our observations in terms of the outcome of the implications thereof. Then I will, at the end, on the last slide, conclude in terms of just summarizing the perspective of the minister. Sonabile, if you can come in and share with the members of the committee on this court judgment. Over to you.
Thank you, Honorable Chairperson. We begin with the the summary of the court judgment because it gives context even to when we conclude with the implications of that judgment. It was on the 5th of May in 2017 when Mr. Zabalaza Mshengu and 2 others brought an application against the respondents, which included Msunduzi, Mshwati local municipalities, as well as Mgungundlovu district municipality. And I like the fact that, Honorable Chair, in the presentation by the Legal Aid Board, they also made mention of the Association for Rural Advancement. That association Chair, was the was amongst the applicants, the third applicants in terms of this case. The order that was sought by the applicants was an order declaring, among others, there were several orders that they sought, but the one that we feel is important, it was the one declaring that the first and second respondents' ongoing persistent failure to provide the farm occupiers and labor tenants residing within areas of their jurisdiction with access to basic sanitation, sufficient water, and refuse collection was inconsistent with the Constitution, particularly those sections that we have indicated there. This judgment was successful, and those who may have seen DCOG's annual performance plan for 2020 and 2021 financial year will observe that at page 15 of this annual plan, we did report on this judgment at that page 16 and 15. And I'm sorry, Chair. But the sad part is that by the time the judgment was passed away or was delivered by the court, Mr. Mshengu, because he was already over 100 years of age, had already passed away. If we can go to the next slide, where we are then getting right into the implications of this court judgment. What we then did, Honorable Chair, is to ensure that the paragraphs where we draw these implications, we also just also give an indication of the paragraph where one can get what we are talking about if one can take time to read the judgment. As well, Chair, there are 8 implications that we have taken out of this judgment. 4 of these do not necessarily have to do with water, but have to do with basic services in general, but the other 4 are specific to water. We start with the one that is just now for basic services, that municipalities have a constitutional obligation to focus on the provision of basic services and may not prioritize other services at the expense of basic services. So it just shows what the huge constitutional obligation that municipalities have in terms of providing basic services, that they can't, and they have to prioritize it. The second one that we have identified is that the obligation to provide water and sanitation for farm occupiers and labor tenants rests on the municipality as the Water Services Authority. It does not rest on landowners. Even in instances where a landowner may have been contracted by a municipality to provide that service, but it does not mean that because the municipality has contracted, say, a landowner to provide that service, then the municipality as a Water Services Authority can just then wash its hands of this. No, the court made it clear that that obligation still rests with the municipality as the Water Services Authority. Also, another implication is that a municipality that is a Water Services Authority has a duty to ensure that landowners or other intermediaries provide access to a basic level of sanitation service to those living legally on their land. So that is the another obligation, implication of this judgment. We also move to say that given that a landowner has a secondary obligation under sections 8 and 27 of the Constitution and the Water Services Act, he or she cannot unreasonably deny the municipality access to his or her farm in order to install the necessary infrastructure to ensure the provision of services. So meaning that a landowner has, in terms of this judgment, has an obligation to give a municipality permission to his or her property in order for the municipality to erect or install whatever necessary infrastructure there may be to ensure the services, the provision of those services to the farm occupiers and or labor tenants. If we can go to the 8th slide. The other implication, Chairperson, is that even a municipality that is not a water services authority cannot absolve itself from its constitutional responsibilities by simply contending in court that it is not the water services authority. So it just shows how important this obligation is on the municipalities, that a municipality just cannot come up with that argument that no, we are not the basic services authority, therefore we shouldn't be questioned about the obligation of providing water to communities. That will still be required out of the municipality, even if it is a water services or not. Another one implication is that a municipality that is a water services authority must adopt and implement a plan or policy that makes a special provision for farm occupiers and land tenants, and must provide a reasonable plan for progressively realizing their rights in order to comply with its obligation. So it is important that municipalities then have policies, they adopt and implement a plan or a policy that will make a special provision for farm occupiers and land tenants. So that is one of the things that we have taken out as one of the implications of this judgment. And we proceed to say another implication is that as farm occupiers and labor tenants are vulnerable and poor, with the majority of them even ignorant of their constitutional rights, it is incumbent upon all municipalities to be proactive in ensuring that farm occupiers and labor tenants have access to services. What I like, again, Chairperson, is that this point that the vulnerability of labor tenants, and it has also been made in the previous presentation from the legal aid, that point that a majority of labor tenants and farm occupiers a majority of them are even ignorant of their constitutional rights. So it shows how vulnerable those people are, and that municipalities then have a responsibility to act proactively in ensuring that they have access to services. Otherwise, those people will remain in that situation forever if no intervention is taken by municipalities. We then, our last point on these implications is that, Chairperson, courts may, and if need be, must use their wide powers to make orders that affect policy as well as legislation, even if such orders will interfere with the doctrine of separation of powers. As we know, Chairperson, that we have this doctrine of separation of powers, but courts under special circumstances are called upon if by the Constitution itself to ensure that they can use their wide powers to make orders that would affect policy as well as even legislation. We have examples of those instances. I'm sure many of us would agree in this respect. If we move on to the ninth slide, we just had our concluding remarks here that the judgment recognizes the fact that unlawful occupation of land is prohibited, something that I'm sure it is known. That is why we at paragraph 63, which is the court stated that a municipality, the duty of the municipality to ensure that landowners and their intermediaries provide services to those who are legally living on their land, that people, wherever they are living legally on land, that is an obligation. They must be provided with their services. That is, no one can argue about that in terms of this judgment. And this judgment, as it is already, the implications already show, it does not only have implications for municipalities, it also has implications for landowners, as we've said that, for instance, in paragraph 63, that if you are a landowner, you can't unreasonably deny a municipality access to your farm or land in order to install that necessary infrastructure for the provision of services to those who are dwelling on the farm. We believe that this is a very well-reasoned judgment and has applied the law correctly. This probably explains why none of the respondents against whom the judgment was made have appealed it. We then, in conclusion, state that municipalities that are failing to provide basic services to farm occupiers and land tenants may soon find themselves being dragged to courts to compel them to provide those services, because people who will be dragging those municipalities to court will be using this judgment as a precedent for saying, no, we need this. We are relying on this judgment that was delivered by the KZN High Court. Those are the, yes, as far as we could do, Chairperson, in terms of this part. Thank you. If I can just take it back to Mr. Mohale to take over. Thank you. Thank you very much, Chairperson.
No, thanks, Sunabile. That is the update that we are sharing with you, members. And just to, in concluding, we all know that where these incidents happen, and when we have then mitigated the plight of those that will have been evicted, then it creates another set of challenges, because now the law says such people then has to be given shelter. Then you have a queue of the existing list of people who are waiting for shelter or for houses in the municipality. Most of them has waited for many years, and then this matter also creates its own tensions in terms of now. Some people will see it as now is by default queue jumping and the like, but those are the challenges municipalities experience and they have to grapple with, and led by the political leadership in the spaces, they're able to overcome them. And then lastly, Chair, we all know about the district development model as the operating model that we are now as is a major reform that we are embarking upon, and the Cogta has been assigned to drive the implementation thereof, across all the spheres. We are embarking on all of government and all of society to mobilize, and in these 52 district spaces, just to really to begin to urge our communities to begin to find each other, municipalities to find the traditional leaders. I mean, in some of the areas, you find the attention between the municipality and the traditional lead. And for the farmers, there's not direct engagement. We're urging, because we are all in this together. The slogan of the DDM is that no one should be left behind. And we already this input that we've put in is also conscientizing us, as Cogta, a lot of work that has to be done to assist the Department of Agriculture and the sector in the agricultural sector, just to make sure that there's a homogeneity of purpose in that particular space. A lot of task is facing us ahead, but we are here to seize the opportunity and drive as assigned by the president, and we should be in a position to see some strides, whereby the distance between the communities in each one of these spaces is really narrowed, and that there's a common purpose by all of them. I'll park here and conclude on that note, and over to you, Chairperson. If there are any questions, we will appreciate, we can fill them from our side. Thank you, Chairperson. Over to you.
Thanks, Mr. Mpo. I missed out your surname.
Morale,
Morale,
yes.
okay.
Morale, yes.
Well, thanks, Mr. Mpo Morale, and your colleagues for the excellent presentation on behalf of Cogta. And I'm sure honorable members and our guests have taken note of all the presentations, including the important and the landmark judgment that has been made by the KwaZulu-Natal High Court relative to the rights of the farm tenants, laborers, and those who are in fact at the receiving end on those conditions. Colleagues will have to invite for questions now for both the presentations that have been made by Legal Aid and as well as Cogta. Just another correction. I've been advised that in fact Legal Aid represent the department that is correctional and justice. So there will be no further follow-up by the correctional services and justice department. So they are in fact as a unit within the department responsible for the areas on behalf of the department, that is the correctional services and justice. Can we then invite hands? Can we invite hands? We've got the first hand of Baba Undumiso Kapa. For now, the second one is the Honorable Twete, Honorable Masipa. Maybe we should proceed from that point. Babu Kapa, followed by Mamu Twete.
Thank you, Chair. Thank you, Chair, and thank you for the presentations. That first presentation of legal aid, to me, let me say, it's one of those presentations that you can say there is light at the end of the tunnel. So for that reason, I think, and also appreciate your words. You said this is an excellent presentation. Now, I just have some few clarities. One is that on the, what is this? The slides 28 and 28 to 30, the presentation indicated where there was problems, and then they come with solutions, which is also very good for me. But I noticed that somehow on that slide 25, where they were having strengths and weaknesses, and their weaknesses are read on the right, it doesn't seem to me that there were proposed or prospective solutions on that. But otherwise, unless for me, the proposed solutions are scattered somewhere along the report, but that's example of the other slides where they come with solution problems and then solutions. To me, that's great. It takes me to where I used to ask a question, which usually is forgotten. when I ask, are there any legislations that need to be reviewed or amended in order to improve the situation or performance? So I'm very happy on this part. The other one is on the burial rights. Here, there's a slight problem for me on the burial rights. This is one of the areas which, when we went to the oversight, people were really crying for this over this situation. But now I think there is somehow a contradiction between these burial rights and also the possibility of the owner to refuse. To me, there's a weakness here. If maybe there can be somehow where it is established that it must be compulsory, it must be a requirement for the farm owner to make these people have their rights without having to suffer and go to law. That is one. And then the last one on legal aid is that condition of farm workers and farm dwellers in the event of a new occupier. That also was a serious cry. Many people were saying that when they were there with the farmer, there was this agreement, there was this understanding, and that when the new farmer comes, he or she changes these situations and they become desperate. I would like to understand on that part, that is there any way, is there no way that this condition, this situation can be improved so that the farmers, I know there's Tenure Act, but now it doesn't seem that it is compulsory for the new occupier that he must respect the people that they find on the farms, because we have the problem that always those people have been there forever, for years, and they have nowhere to go. On the part of municipality again, even there, the only problem is that contradiction of, while the municipality as a water service authority has a duty of this delivery. My worry, maybe this also needs to be clarified, is that now when it is an obligation, but now the requirement to obtain permission from the farmer maybe also should be clarified, because this is one of the areas where people were crying that here the farmer is not allowing us to get water, to get electricity. But now if the municipality has this obligation to me should not be limited by that it should be optional for the farmer to provide this service. I thank you, Chair.
Thanks, Honorable Kapa. Honorable Chwate.
Thank you, Chairperson. Endorsing a presentation, legal board and SALGA. Let me start with questions and comments as the legal board. Chair, Kumamu Mandidi Kula. On slide 4, Chair, of the presentation, ELRMF was transferred to Legal Aid SA. I think in 2019, if I'm not mistaken, Chair. Now, there, LRMF has other components, such as mediation, as form of alternative dispute resolution. However, Chair, legal aid states that it took over the legal representation of LRMF in January 2022. Now, Chair, my question on this regard to Legal Aid SA is that what happened to the other components of the LRMF? Are they remaining with the Department of Agriculture, or they also took over of those components? I just need clarity on that one, Chair. The second question to illegal aid is on the issue of the 33 million that was transferred. I just need clarity, Chair, on that one. This 33 million that was transferred, was it a once-off payment? Was it a once-off transfer? Who transfers it? Who transferred it? Is it the Department of Agriculture, Land Reform and Rural Development, or it was National Treasury? I'm asking this, Chair, because on slide 9, there is a contingent liability of about 144 million, 0.6. And then there was a transfer of 33 million. Can we get that clarity, Chair, so that I might have a follow-up question when that one is transferred, is answered. The last question on illegal aid, Chair, is on the issue of labor tenants. Uyabona ke Sihlalo, kule issue of labor tenants and sometimes how the department and other stakeholders handle this matter, it makes one not to understand ezinye izinto esenza uhlobo esenza ngalo. Remember, Chair, during one of our oversight visits, labor tenants were upset about the issue of not having farmers not giving them burial rights. And when one farmer sells the farmer to another one, this other one will come and claim that their houses is part of the farm. So it's no longer their homes. Now, Chair, I want to understand the legal aid on this issue. You have people that you have farm laborers that are staying in this farm. There's a land that is lying fallow there, or there's a certain portion that is lying fallow there, and nothing is being done, and no plans of developing or farming that certain land. What is so difficult to legal aid to expropriate that land without compensation? That part of land for land tenants and land labor and farm dwellers, what is so difficult to expropriate that land? I'm asking this, Chair, precisely because also these entities of ours must align themselves with the current resolutions of the state. I've been noting the continuous trend of the government officials of negotiating with the farmers. How much can you sell this portion of people? And that was the first phase of willing seller, willing buyer. The second phase that they should implement is to expropriate without compensation for the people, and not stop doing these things as unnecessary of. And yes, I really would like to understand what is so difficult to do that. What is stopping them from doing that? The last one, Chair, the second last on legal aid, on slide 22 of their presentation, where they are talking about tracking and monitoring evictions. They have 64 local satellites offices, 64 local offices and 64 satellite offices. But on the previous I'm confused. I'm confused when it comes to that, Chair, because on the previous slides, I will take just one province, Eastern Cape. Eastern Cape, Chair, they presented that they have 3 personnel, and they quickly jumped on the following slide where it will talk to the regions. But one would summarize and conclude that there's only 3 personnel of legal aid in the Eastern Cape for the entire province. There are outstanding cases, and some of them we know and we've had. Some of the labor tenants and farm dwellers there, umzekelo eQumrha, one of them, chairperson lifted earlier on in the meeting. If you have 3 personnel, akurizeki issues of incapacity there. Is the legal board, is the legal aid board in the Eastern Cape, I'm just listing one province, capacitated enough to deal with such issues? And also in the same slide, there is not in the same slide, there's also a mention of illegal aid conducting trainings and workshops. Can they tell us where have they did these trainings and workshops, and what type of trainings are they conducting? Even if they make one example, an example of one province. That was my last question on illegal aid. SALGA. SALGA, Mr. Mpoma Mohale. You can't be waiting for a court judgment to compel the municipality to provide basic services to farm dwellers that are evicted. It is their basic rights. It is their basic right to have basic services wherever they are. There is an issue that has been raised here that some farmers prevent the municipality from providing certain basic services. You can't be negotiating on that. That cannot be the reason, because that farmer is violating the basic and the constitutional rights of those people as South Africans. Initiate and evoke such things, comrades, officials. Funeka negotiate yonke into negotiate in the expense of our people. We can't allow that. The question that I have for SALGA Chair on this issue of basic services. There was a presentation, I believe they were part of the meeting from the onset, Chair. It has been indicated by the department that there are DDM projects, the district development projects, abanazo with the municipalities. What are these projects? Are they aligned with what we are talking about today? If yes, where? How many have they been implemented? Just give us one example. I'm asking this, Chair. If not, what are the strategies or remedial plans abanazo as SALGA to address this issue that we are talking about today in each and every municipality, even if they just flag one? Because, Chair, what they are saying here, it seems like just a talk show. It seems like it's just more of a lecture about a court judgment and stuff, but it's not really talking to what are we going to do from now on, or what we have we been done to address these issues. Thank you, Chair.
Thanks, Honorable Twete, for your questions. Honorable Masipa, and then followed by Honorable Matthias.
Yeah, thank you very much, and thanks to the presenters. Yeah, I think Metswete has covered me, but I just want to go back to the question of the Land Rights Management Forum that was transferred to Legal Aid South Africa. What was the budget that was attached to this Land Right Management Forum? And if that budget has been transferred to Legal Aid, would it give the Legal Aid more capacity to do its work, as we have heard that they have got really a shortage in terms of really capacity in doing the work? Chair, the other concern that really I'm having is that on paper, you know, the presentations are looking extremely good, but on the ground, you know, it's a serious concern, Chair. I would definitely want to hear, like Metswete said, the district model. How has it been applied in terms of really assisting the work of the farm dwellers and the labor tenants on the ground? Thanks, Chair. Those are the two questions that I wanted to ask. Thanks.
Thanks, Honorable Masipa. Honorable Matthias.
Baba Nonsela ndiyabulela ba. Ngele thuba. Look, Honorable Chair, just to help my colleague, Honorable Masipa, in slide 6 of the legal aid, the kind of answer for the question he has raised perhaps could be found on that page. I'm not speaking on behalf of the legal aid. They are more than capable to speak for themselves. However, whilst I'm on legal aid, Honorable Chair, slide 6, the transitional arrangement where the legal aid took over the land rights management facility and land rights management unit. They give us broad figures of cases. Some of them are current or active matters. Some are being held in abeyance and all of that. They don't tell us in which specific provinces these cases are. Perhaps it will be in the interest of the joint committees to know in which provinces these matters are more frequent. I'm just as concerned as other members about the handing over of land right management facility to legal aid without the concurrence of the committee, especially the Committee on Land, on Agriculture, Land Reform and Rural Development. Well, it is an operational decision, of course, that could be taken, but it would have been good that the committee is informed about this, so that when we go about public hearings and doing constituency work, we're able to directly refer victims of land tenure and victims of evictions directly to the legal aid, than to waste time of referring such cases to the department which has abdicated on its responsibility to deal with such cases. Well, I think legal aid, Honorable Chair, is helping us in some way with the recommendations they're making. How I wish that other departments, as they will be making further presentations in the days to come, they're able to follow what legal aid has done in its presentation. They identify a problem and provide solution in a form of recommendation to various organs of state, parliament, and the executive. I think that is very commendable. But going forward, would like to get legal aid to provide us with information about how many of these cases that have been handed over to them and the new cases that they have received since taking over, they have successfully resolved as the legal aid. Well, let me go to Cogta. And with Cogta, I'm not ready to say much, because Cogta in their presentation, they are regurgitating what we all know without providing any substantive proposals or solution. I just want to ask Cogta one simple question. Whether do they know a dam in KZN called Jozini? And whether do they know that that dam is under private ownership? That dam is owned by a so-called Mr. Seneca. Do they know that villages along the N2 just adjacent to the Jozini Dam have no clean running water. Yet there is a dam alongside their settlements. Do they know that? They speak high on the duties and responsibilities of government, local municipalities and that. Do they relate what their theory tells them and their realities on the ground? I would like them to answer these questions. Because it's like we're high on theory and very shallow on practice and getting into grips with the realities of the people on the ground. Thanks, Honorable Chair.
Thanks, honorable members. Thanks for your questions. That was the last question from Honorable Matthias. Can I also just add a question, because I think part of it in greater detail has been covered by Honorable Chwete, that relates to, firstly, to legal aid with regard to tracking and monitoring evictions. The issue is about the resources or the infrastructure on the ground, 64 and 64, that is 128 offices. The question is the extent of the impact, because I didn't hear properly that legal aid has been able to get the ground on the ground with regard to the 128 or minimum of their presence on the ground, particularly with regard to awareness programs, the extent to which, for instance, you would even embark on outreach programs that are focusing on farming communities, so that you in fact engage on these issues that you've covered. That's the first one. The second one is with regard to the analysis you've made, or with regard to, that is on page 20, that is on slide 25, that is the steps to deal with weaknesses. I'm quite comfortable with the work that you have done, particularly on the identification of the strengths and weaknesses. But I'm not sure on the recommendations, because your recommendation, as again, Honorable Chwete was saying on the recommendations, whether you have made a total account of all the weaknesses there. And if you can maybe just cover that point. Then the last point is with regard to Cogta, the issue of the unreported evictions. One honorable member earlier on raised the issue relating to a situation whereby even officials from department would in fact facilitate movement of people who are illegally evicted, that they in fact be supplied with material so that they start to build informal settlements in various municipalities. The question would be, to what extent as Cogta and as well as municipalities have we been able to first stand up with regard to the violation of rights? I'm not meaning that you should not in fact make the interventions that you have done with regard to providing the appropriate accommodations and interventions. But there is this side of violation of right. Maybe if you can, Mr. Mohale, cover me or clarify me with regard to that area, because I don't think Cogta should in fact waive its right to ensure the enforcement and the protection of rights, particularly when these straight cases of rights violation with regard to eviction. I think I'm covered broadly on other areas. Thanks. I haven't seen any additional hand, so I would allow both legal aid and Cogta to proceed with responding to the questions. Can we get legal aid first?
Thank you, thank you, Chair. Most of the questions will be responded to by the CEO and the legal executive for land matters. But let me just touch on one matter, one issue that I think I could possibly make a contribution. It is an issue about water rights. I think we must understand, appreciate that water is a national competence. Nobody owns a river. Even if a river runs through your farm, that river, there's still a national department which has got a right over that water until such time that you've applied for authority in terms of, I think it was mentioned by one of the presenters in terms of certain section of the Water Rights Act. So the issue raised by Ndade Matiase about the dam owned by Mr. Senegal. I'm not sure whether Mr. Senegal built the dam himself or whether it's a natural dam. So those are issues that we need to clarify ourselves. The other question that I also want to respond to is, which was raised by Metro, about expropriation of land. The question is, why is legal aid not expropriating? We don't have the right to do that. We're just a functionary within the Department of Justice. It is the politicians which must go and amend Section 25 of the Constitution. And then the functionaries within the land matters will be in the position to do that, not legal aid. Legal aid has got no right to do that, to expropriate. Us is just to protect the rights and submit submissions to court and to whoever about the rights of people who are affected by those. Let me stop there and allow the CEO and Mr. Mbenza to respond. And also, I think the issue of the 33 million, I think the CEO will be in a position to explain. Thank you. Mantiti.
Thank you, Chairperson, and thank you, Honorable Chair. And thank you, honorable members, for the questions. I will start with the questions that were posed relating to the transfer, governance, and the budget. And Mr. Mbenza will deal with the questions that were posed by Honorable Kappa that relates to conflicting rights with regard to burial rights and change of ownership, and also that by Honorable Tswete on the labor tenants and the why we're not expropriating the vacant lands. And with regard to the transfer of the LRMF to legal aid, I would like to put it on record that a decision was taken by the Interministerial Committee in 2019. As it's explained, it's the opening sentence in our presentation, but the actual transfer of the function happened 6 months ago on the 1st of January 2022. And from the time that a decision or a recommendation was made by the Interministerial Committee on Land, negotiations commenced between the Department of Justice and the Department of Agriculture. As the honorable members will appreciate that legal aid is an entity of the Department of Justice and Constitutional Department. So an interdepartmental task team was set up, led by our shareholder, the Department of Justice. That was set up in 2020. The work of that interdepartmental task team culminated into an MOU being finally signed by the Ministers of Justice, of Agriculture, and also of Public Service Administration in terms of the framework for transfer of functions between departments. So that was only concluded at the end of the previous year financial year, around April, May this year. But to honor the date of the transfer that was agreed with the ministerial committee and also with the interdepartmental task team, Legal Aid Board, then that is the Legal Aid Accounting Authority, that is the Board of Legal Aid, then provided from money from their surplus account to effect the transfer in January 2022. So if the Legal Aid SA Accounting Authority did not avail that funding, the surplus funding of 35 million that they required from Treasury to utilize towards taking over this function in January, would have only taken over the function after the Department of Agriculture has availed the money on the 1st of April 2022, which would have been 3 months later than what was proposed as the transfer date. So I just wanted to contextualize that. The 35 million was availed by the board in January 2022 to enable Legal Aid to take over the function as a date was agreed by the 3 departments. Our shareholder, the Department of Justice, and also the Department of Agriculture, and also sanctioned by the Department of Public Administration in terms of the PFMA framework relating to transfer of functions. Between January, February, and March, the end of the financial year 2022, the task team between DOJ and Agriculture and also Department of Public Administration then concluded the paperwork, the MOU, and also the transfer documentation to enable this transfer to be in line with the applicable governance frameworks. And as Legal Aid, we were particularly happy that both the Department of Justice, Agriculture, and Public Administration and our respective executives were able to conclude that in line with the prescripts relating to transfer of functions. Because if this was not done, that would create problems for Legal Aid in terms of audit and also us attributing for any funding that will come for this function, and also our funding from Treasury, our allocation from Treasury. Before an allocation from Treasury is made for this new mandate, we would have to provide documentation relating that this function was transferred in line with the applicable governance prescripts. So that's where the 35 million comes. It was a seed fund that the Board of Legal Aid provided for the 1st of January 2022 transfer to happen. Once the MOU and the necessary documentation were signed by our respective executives, then the Department of Agriculture availed the 33 million, which was for their 4th quarter of 2021-2022, meaning that's the money that they would have used between January and the end of the financial year. They then transferred that 33 million to Legal Aid SA on the 1st of April. Then the funding for the subsequent years, which would have been the year that started in April 2022, this year, ending March 2023, we have to have an allocation from Treasury to acknowledge that Legal Aid, above the civil, above the criminal work that they do, they have a new land mandate that must be funded by the state. Our shareholder, the Department of Justice, in collaboration with Agriculture and ourselves, made presentations to National Treasury and accorded National Treasury the paperwork that relates to this transfer. And to that end, that's where we have the slide 9, where it was agreed that our baseline allocation for this financial year would be 89,603,000. And because of the handover file that had pending matters and matters in abeyance, those 740 matters were not finalized. We took them over as part of the transfer, but the contingent liability for those 740 files was amounted to 114.4 million, which then it's not possible for us to work down the 740 files in 1 year. We then submitted a projection that based on the work or our assessment of the handover files, we may be able to process or finalize 25% of that 740 handover file. And hence the projection of funding of contingent liability for our first year of operation is not 144 million, but is 28 million. So for this year under review, or for this current year, we are going to need 118 million. And of that 118 million, we only have the 24 million that we rolled over from the 35 million of 2021-2022, and we also have the 33 million from the Department of Agriculture. National Treasury has not yet accorded us the allocation, and through the submissions by the DOJ and in the bilateral with National Treasury, we will get this funding end of December or beginning of January during the midterm budget review. So that is the current status of the budget and the transfer process. And with regard to our national footprint, the 64 satellite offices and the 64 local offices, that is the existing footprint of Legal Aid SA that is currently servicing for criminal, civil. So in addition to our mandate, those existing offices will then have an added mandate. So the positions that you see of 4, 5 per province are additional to those local offices to be able to then deal with this new mandate. For instance, Honorable Chwete, in the Eastern Cape, we have 10 local offices at Aliwal North, Butterworth, East London, Graafrenet, Grahamstown, King Williamstown, Mthatha, PE, Gqeberha, Queenstown, Uitenhage, and we do have a provincial office. Above that, we do have satellite offices as well in the Eastern Cape. We also have a satellite office in Aliwal North, in Sterkspruit, Craddock, Somerset East, Fort Beaufort, Statenham, Bizana, Lusikisiki, Mount Frere, Humansdrop, Elliot, and Kirkwood. So in all those 18 offices, we're gonna add resources that are going to increase our capacity so that we can deal with this new mandate. And that's the resources that we are saying will only be able to roll out fully once we have received the allocation from Treasury, and that is anticipated to happen end of December this year or beginning of January 2023. But in anticipation of that allocation, we have then commenced with the recruitment of the additional resources that are going to be placed in these offices that we speak of. Those are existing footprint. We're not going to set them up. We're only increasing capacity to accommodate this land, the new land mandate. And above that, we have an advice line that caters for all languages. And for those that do not have resources to call, we have a please call me facility that they can use and would get back to them in the event they don't have money. So that's the available channels that we currently have within Legal Aid SA. And with regard to Honorable Madaise, that we only show the categories of the land rights violations on slide 6. We don't indicate where they, in which provinces they are. We have provided that on slide 19. The one on slide 6 was just as an introduction to highlight how much we have taken over from agriculture. But on slide 19, we go in detail per category, per province, so that we can also see where we have the greatest violations and where, so that we understand that the demands that relates to these respective categories.
Me Mantiti, Naki Matias, Aki Mataise.
Ntate Matias a profusely ke kopa tshwarelo ntate wa ka.
Matias me Mantiti.
Ntate Matias.
Order, Honorable
Ke kgopela
Matias.
tshwarelo. Ke kgopela tshwarelo.
Thanks, thanks, Mama Mantiti.
Yes. I will then ask Ntate Thabiso to speak to the burial rights and also the change of ownership dynamics. Thank you.
Thank you, CEO. Thank you, Chairperson. With regard to the issue of strength and weaknesses, saying that we did not propose any solutions. Solutions are covered in slide 27 onwards. The burial issue, we know that this is a thorny issue, but what we are doing currently, we are just trying to think about strategic intervention, as we did in that basic services case that has been mentioned, that Mshengu matter. The Mshengu matter was funded by Legal Aid. With regard to the new farm owners, so in terms of the law, the new farm owners are not allowed to interfere with the rights of occupiers. So the law is clear on that. But I think what we need to do, we need to educate the occupiers. We need to tell them about access to Legal Aid South Africa as well. We've already drafted some pamphlets that we want to distribute as well to farm owners, to farm occupiers, because we want to teach them about their land rights. Because if they don't know their land rights, they won't be able to see that the landowner is interfering with their rights. Expropriation of land, that one, it's a thorny issue. Judge has already dealt with that issue. But what I can say with regard to that, I believe that it is possible to expropriate land with zero compensation currently within the current legal framework. I think there was another question with regard to CEO has covered the figures. I think that's all, CEO. I'm not sure whether I've left out.
There's one from Tate Kappa relating to the municipality, the contradictions in rights.
Oh, yes. Okay. With regard to municipalities, it is clear from the judgments as well as from the legislations that municipalities, they've got a role to play especially when it comes to access to basic services, when it comes to the emergency housing as well? I think that was the question, CEO.
Thank you, Tabiso. It relates to having to request permission, the limitation of rights.
Okay, did not get that, the limitation of rights when it comes to, or whenever they want to enter the farms. I did not get that question, CEO.
Water delivery by municipality when the rights for them to provide water to the farm occupiers is limited by the farmers' rights.
Oh yes, yes. With regard to that, I was an attorney in that Mshengu matter, the one that has been mentioned by Cogta. So what was happening previously, the municipalities, they were just saying that they were not getting access to farms whenever they wanted to install basic services. So my question was, in that matter, I have never seen an application that was brought by municipality compelling the landowner to give them access. So I relied on those issues in that case. And I was successful because there's nothing, because in terms of the law as well, Esther, it says that you can't prevent an official of the state whenever they want to perform their duties. So that section has never been used as well. So with regard to that, I say that the municipalities, they do have, in terms of the legislation, as well as that Mshengu judgment, they do have a right to access to farms in order to install basic services. Thank you.
Tabi, so there's one more question that was asked by Ms. Chweta. Is it the training and workshop? When did you do it and where? I think that was a question that has not been answered. Can you please give us?
No, thank you, Judge. With regard to that, we have conducted training in KZN, Western Cape, as well as Gauteng. We trained the attorneys that are providing legal services to farm dwellers, as well as to restitution claimants. So with regard to training the occupiers, that is on the way, but we have been invited. We attended the workshop that was organized by Women on Farms in the Western Cape, whereby we did talk about their rights as well. So we have received a number of invitations from NGOs around KZN as well as Western Cape with regard to, because they want us to come and train the farm occupiers. Thank you.
Well, I take it that Ms. Chweta would like to know, when are you coming to the Eastern Cape to do training? I'm sure that is why she asked the question.
No, thank you. Thank you.
Can I clarify that one, Chair?
Then.
Not only one province,
yes, can we clarify that? Because I did
would like to know all
coverage
9,
as well.
not focusing on one province. I was just making an example of one province.
Yes. No, I understand that, ma'am. Eastern Cape is a very wide, big section with a province with a lot of problems, and I think it should also be prioritized. I appreciate that.
Okay, can we have one center, please? Tabo, can you come in, please?
Thank you, Chairperson. With regard to thank you, Chairperson. With regard to Eastern Cape, we are just planning the training before the end of the year. So we should be able to train occupiers as well as attorneys before the end of this year. Thank you.
Okay, thanks, Mr. I'm sorry, Ms. Mantiti, are you done with your overall questions? And the chair of the board as well. Any further noted questions that you still want to cover?
We are covered, Chair.
Okay.
Honorable Chair, thank you so much.
If we may have missed out on any questions, I think at any time the committee can then address a letter to us to answer a question that we may have missed. We always available to answer that in writing. Yes.
Okay, thank you, Chair. Can we then invite Cogta, Mr. Mohale, and your team?
Oh, no, thank you, Chairperson. And let me also welcome the the comments made and also the questions that were raised by members. Member Twitter indicated that we covered the court judgment. If the committee asked us to expand on it to ensure that we are on the same page and also to share our perspective. But on the second question of DDM, I'll pack because it is related to what Member Masipa has indicated and also the chairperson, but and also Member Matias. I will respond after Sonabile has responded in terms of obligations, which I think he should respond, and then from there I will then come back on the matters of the DDM and related matters. Thank you, Chairperson. Sonabin, if you can please respond on that matter raised by members. Thanks.
Yes, Honorable Chairperson. I think, Chairperson, the question from Honorable Kapa has already been dealt with. I liked the response that Thabiso did give in terms of this question. Perhaps mine would just to add on what he said, because really the farmers or landowners still have an obligation to provide, to make the working environment to be conducive. So providing water to labor tenants would be one of those. But perhaps because the judgment was more on about the responsibility of municipalities, maybe what one can say in that regard is that in an instance where a landowner, for one reason or another, cannot provide the, water, then the municipality has an obligation to do so. I'm just thinking now as an example, say a landowner has a tank or tanks on the farm, and those tanks are there to collect rainwater. You may then imagine that during winter, when there is no rain or during the periods of drought, those tanks would run dry. Then in an instance like that, a municipality has an obligation to step in because the landowner might be saying, no, I don't have sufficient resources really to maybe to dig a borehole. So the municipality will then have to come in, perhaps drill a borehole if that is the best solution to the problem, or may even have to provide those water tankers, maybe say weekly or whatever period that may be determined to the farm. So that is how these obligations are. We are not denying that the landowner has that responsibility to provide water and other services on the farm. But the municipality, in case the landowner cannot do so, has a duty to then provide those services. The municipality cannot use an excuse that no, it's not our land. They are obligated to provide those basic services that are needed. I think then, yes, I was just adding to what Thabiso had said. I think then, Honorable Kapa, you are then covered. I will then hand it over back to you, Chairperson, so that Mr. Mohale can then, complete the answering the other parts of the questions. Thank you.
No, thanks very much, Sonabi. What I can indicate to the members is that obviously the municipalities must up the game in terms of vigilance, in terms of being proactive. As some of the members, it's like municipalities have to wait for somebody to report these human rights violations. But obviously, the municipalities have to up the game and ensure that where there are these violations, that are occurring on the farms, which will probably pick up the sound bites in terms from the structures like unions on those farms and also NGOs that are operating and all the stakeholders that are operating in those sectors to ensure the DDM is going to really gravitate all of the leadership to begin to, as a collective to grapple with all these challenges. That is how I would comment in terms of acknowledging that the vigilance might be maybe at a particular level, it has to be up. And then in our forums that we have of the intergovernmental relations forums, these matters will then be flagged accordingly to ensure that there is an appreciation and a requested response to it. Coming to the other questions on the district development model that were raised across all the members, just to indicate to the members to say the district development model as an operating model of the state is a major policy reform, and mind you, it has been the president have directed our minister, and it is simply because there's so many manifestations out there in the spaces, and those manifestations that have been blocking service delivery has to be really be broken. So the silos that have been there, across the spheres, intra-department and across the sectors, has to really be broken so that we have seamless operations. It's a major policy reform, and that's why we had to go the route of the pilots, which we use to ensure that we are able to get some lessons out of it in terms of the three space pilot areas that have been launched by the president. And then we are now, we are deriving the lessons out of it. We are actually consolidating. In fact, next week we should be meeting with the presidency, the treasury, and all the key stakeholders to reflect on the research that has been done in terms of the analysis of these pilots, and then we're able to then ensure that going forward we're sharpening it. Mind you, also members, that we were initially supposed to do the 3 pilots in terms of the DDM, but rollout. But then we were also then asked that we must roll it out throughout the country. So there are 1 plans in all the 52 districts spaces, the 44. I mean, yes, and the 8 metros and the 44 districts. Now, this 1 plans. I mean, the DDM is all about really marshalling all of us in terms of planning together, and also budgeting, and also then making sure that we are implementing as a collective, especially focusing on the catalytic projects that will have now, that are now expressed in those 1 plans of each and every district. And then those catalytic projects are actually dependent, they are derived from the endowments in those particular spaces. So I'm not lecturing to the members, I'm just indicating in terms of the process that we are really grappling with. And then there is a DDM in action that we always share with members and with any other stakeholder, is where that is driven by the minister in the Eastern Seaboard, where there's the program there. It is cutting across a few districts and across the 2 provinces, and it has got its own complexities, but there is determination to really ensure that it begins to yield the necessary results. And some planning work has already been done to begin to unfold, to ensure that the intention of making that particular space to really be exploited is starting to yield the results. So members, just to indicate that over and above, we're coming from COVID, and then the districts have been asked to do the economic recovery plan. Those are the things that been put together by the district spaces, and then they're being used to try and and generate and to restore the economy that has been battered by COVID in many ways. The DDM, and then we have champions that have been appointed by the president. And the next week, I know is a declared. This month is the week of local government week or month, and the DGs and the presidencies, the champions, all the ministers are being deployed in all the spaces to begin to track. And their responsibility of this champion and the MECs who are appointed and the district mayors is simple to go and unblock and assist us as Cogta to also unblock the blockages that are there out there, and also to, in particular, also to look at the state of municipalities within that district. You'll find out, as you know, within the district, you'll find out one or two that are problematic municipalities. Then the leadership must be able to deal with those challenges per se. So the DDM is already rolling. But we are still putting building blocks. At the same time, we're also doing a lot of unblocking wherever they arise in many ways, either some of them through our minister, in other cases through the champions as they find themselves faced with those type of things. So it is a major reform, and some of the national departments and provincial departments, most of them are coming to the party, and then others we have to persuade them to ultimately jail. And then there was a cabinet meeting recently, and there is a commitment that the route to go and the platform should be the DDM, and then we should all ensure that we begin to appreciate and respect the new policy posture that we are taking as government. So on the issue, other matters of the Jozini Dam, they've been explained. It is there are a few. I mean, Loskop Dam. I mean, some Polokwane gets water from Loskop, and we know that there are pipes that goes to Polokwane city, and then but people along the way do not get water. All those type of things have been dealt with. The good part with this DDM is that we are now, it's no more DWS problem. It is our problem, all of us, and also including the private sector, to really ensure that we own up and then grapple with it and dispose of that particular challenge that manifests. Per se. Yes, you may feel that maybe we are talking.
Mr. Mohale, can you wrap up?
I'm wrapping up. I just felt that the DDM is a new form, and then we are still putting building blocks, and then else in short, I'm saying we are now on a new trajectory, and then it will be yielding. But I do also appreciate the anxiety from members about maybe it's hyped too much, but very little in terms of action. But something is being done where I'm sitting ourselves as officials, doing our best to support our political leadership. Yes, Chairperson, let me pause here. Thanks a lot.
Thanks, Mr. Mohale. Thanks for your presentation together with your team, and also thanks to Legal Aid for their comprehensive presentation as well. And we take note and comfort from the commitment that we have made that we should, in fact, on the questions that remain outstanding and not properly clarified, that we can, in fact, follow up, and then you can make submissions in writing so that you clarify those points. This includes also, I think, the issue of expropriation, the question how it was raised, and the manner that Tabiso has, in fact, clarified it. I think the central point here, colleagues, that is from both Legal Aid and Cogta, is not for you to do our job, but it's essentially for you to help us, to help guide us through advice, particularly on the practical experiences that we have come through with regard to the issue of labor tenants, where you would find that at the end of the day, after almost intergenerations who have been staying over the farms. And then you have also the farmer rewarded by getting the portion that is allocated to the labor tenants being bought. So you have a double blow wherein, in fact, the money that could have been used to recapitalize the area where labor tenants are, in fact, resettled. And in fact, that money, in fact, is rewarding the farmer who has benefited from the skills and the dedicated labor from the farm laborers over a long period. So those are kind of experiences that necessitate that question. And thanks for Tabiso from the clarity. And I think that's the area that you would need maybe to elaborate on as part and parcel of your additional submissions that you made. We thank overall the submission that has been made and responses made by Legal Aid Board, including the guidance that have been made by the board chairperson and his team. And we welcome and appreciate their attendance as well. Similarly to Cogta, having taken your time out of your engagements and made sure that you make the comprehensive presentation, including the responses, Mr. Mohale and your team. We appreciate that and want to thank you again. I didn't mention the CEO of the Legal Aid Board. My apology for that. Thanks, CEO, for the coordinated work that your team has, in fact, through your leadership and guidance, presented. Honorable members, from the presentations and the responses made thus far, I'm noting there are two hands, unless these are historical hands, that is Honorable Matthias and Honorable Twede. My assumption is that these are historic hands, or you want to clarify, Honorable Matthias and Honorable Twede?
It's not a legacy hand, Chair, but
okay.
On your summary, Chair, you just said the questions that are not adequately answered can be submitted in writing. So for me, that one is sufficient. Thank you, Chair.
Thanks, Honorable Twede. Honorable Matthias?
I think, Chair, rule that hand out of order. It's a historical hand. Rule it out of order. That hand is out of order.
Thanks, Honorable Matthias. Thanks, honorable members, for your support and courage so that we tread the way towards realizing the mandate that has been given to us by the National Assembly in preparation for the submission of our report at the conclusion of the task. Honorable members, we need also to remind ourselves that a similar sitting is still outstanding for the next Friday. So if we can collectively ensure that we again ready ourselves to reconvene on that date. Having said that, I haven't seen Honorable Mandela back to see if he's got further comments. I've checked on the platform, I haven't seen him. And I think having said that, then it would mean that unless there are announcements, Mr. Sagaza or Mr. Sagaza, any announcements you want to make?
Not at this point, Honorable Chair. Thank you.
From the DALRRD team, any announcements? Any announcements? None. Honorable members, let's declare that the meeting is adjourned until we meet again next week. And thank to everyone and your indulgence in this regard. Thank you. The meeting is adjourned.
Thank you, Chair.